And reforms in this case, and this is where we always seek to demystify perceptions that exist. One of the common concerns, and this one I will share, having facilitated across these sessions, one of the core concerns we've been receiving is that the perception first has been government always seeks to control. No. This time, we wish to show you different aspects of regulation that goes beyond just regulation. It's a question of how do we become facilitating? How do we make the sector become efficient and effective in their execution? Remember, these are sectors that the government does not per se participate. That's why it is non-governmental. So how do we make it better? Now, some of the basics or the specific aspects we put is for giving effect to freedom of association and conscience. You cannot just associate within government circles, but even non-governmental. And that kind of association then can only come if we give room for self-regulations. And in one of the provisions, you'll find us talking about forums, federations, whereby we give the organizations the leeway and the freedom to set their own code of conduct and rules of operations. Why do we say so? Because our constitution recognizes and enshrines the right of freedom of association and conscience. Number two, to better facilitate the activities of the charity sector in the Republic. In this case, we refer to things like registration, compliance, reporting mechanism, self-regulations, all aspects that can be a plus for the better execution of the activities within this sector. Number three, we seek to streamline the registration and reporting process, which is just a facilitative role. Again, want to make it easy. The regulator will be here to answer some of the concerns. In some of the sessions, we go before ask, how do we intend to get that done? And in fact, that the regulator, once they have this in place, it becomes easy to execute all aspects of registration, compliance, reporting, make it easy. One of the things, in one of the sessions, the Director General promised that everything will be automated, but importantly, the forms, as you see the regulations, clearly spell out every single aspect that you seek to do. There's nothing that has been left out in the regulations. If it's about registration, if it's about reporting, if it's around dissolution, every single aspect of it has been covered. Then you also have to entrench self-regulation in the administration of PBOs. This is one of the main asks of organizations within this sector. Government does not fund it, so why should government be the one to be the effect? No. So the best way is can also create a mechanism of self-regulations. And that's why you find us talking about forums and federations. Within those spheres, organizations will be at liberty to set their own code of conduct. The only thing is just a reporting mechanism back to the regulator for record purposes and for regulation purposes, so that it's a careful balance between the rights of the organization vis-a-vis the citizens of the stakeholders. Lastly, we seek to enhance accountability and transparency in the sector, because once every process is clearly defined and legislated, I don't think it needs any rocket science for you to be able to know how to go about this. For example, you will find things to do like dispute resolution and what have you, clearly spelled out, giving mechanism, right internally from the regulator to the tribunal to the high court, all those have been provided for. And then we did a bit of a comparative analysis just to show you the difference between the Act. The Act has been there, but now that it has not been operationalized, but we felt it is important to just show the difference and show you how it's a significant improvement and importantly plays a key component of facilitation that makes this sector work in a better way. So one of the, or among the few differences we try to give, for example, if you look at the past Act of 1990, which is more or less like the Defunct Act, it provided for registration of NGOs only, but in this case, we register them as PBOs, which is a wider definition. And who then qualifies to be PBO is a wider definition. If you look at the Act we have in place, there are several components, and I'll share shortly how you can be a PBO, starting from being installed, registered as a PBO, exempt, all those four. So you'll find that the scope offered by this Act compared to the past one is a bit wider. Importantly, we have establishing of the NGOs board, but now we have the regulators pay board, that's the team you've seen here. One, it did not have a dispute resolution mechanism in form of a tribunal, but in this case we have a tribunal separate from the regulator, because that one runs under judiciary, creating a sense of independence, but importantly, confidence in dispute resolution. So that if you even have an issue with the regulator, there's a different forum that is independent and can give you a right to fair hearing. Importantly, we also have in the past Act, there was limited self-regulation, but in these ones, provisions as per the regulations and the Act ensure that self-regulations becomes a core component. Lastly, we have issue to do with long registration procedures. Here we seek to shorten and simplify, and that's why you have all the forms in place. At the same time, no sustainable mechanisms for PBOs, but for these particular regulations and set of act, you find that the right for organizations under this ambit of PBOs to carry out economic activities has been allowed. As long as a rider being, it is for the benefit of, it is for the core objective which you registered for. That is to execute public benefit activities. Summary, we broke it down into around 5. First component of the regulations, you have registration and recognition of PBOs. Then you have governance and institutional framework. That's where now you have all these changes. If you want to do changes, how do you report about those kind of things? Then you have the reporting obligations. What are the expectations? Audit reports. When do we consider the financial year of an organization? When are you supposed to comply? Those ones will fall under the reporting obligations. Then we have sanctions, appeals, and processes. In this case, in case you are deregistered, in case of dissolution, what are the provisions? Appeals meaning, if you disagree, do we have room for trying to get a second opinion? If the regulator, for example, has approved for the deregistration and it is unfair, is there room for the same that can be canvassed separately from the regulator? And that one will find that. That's why I was speaking to the issue of the tribunal that is separate under the judiciary. Define core, which is the public benefit activity, which then defines or makes you a PBO. And again, borrowed from the same section 5 of the Act, any activity that falls within the categories listed under the 6th schedule, and you have the Act within, you can be able to confirm. Now the types: national, restored PBOs, international, exempt. For this particular session today, I'm sure the interest is mostly on the international. Let's go back a bit. The main interest is on international PBOs and exempt international. But restored also maybe for the benefit of your downstream organizations. Quite a number of organizations that have registered as foundations and the rest may not have to register afresh. They just need to be restored as status of the PBO, and the regulations have been able to share and clearly provide for that. But for this session of today, I know our key or our key interest is international PBOs as well as exempt international. How do we walk the journey through the two? The requirements, again, generic as per the Act, and the regulations have tried to ensure the same. So the minimum requirements for registration of a PBO, we share that. I don't have to go through the details, but you have it. Importantly, how then do we define INGO? International non-governmental organization means a non-governmental organization with the original incorporation in one or more countries other than Kenya, but operating within Kenya under a certificate of registration. So these are definitions that clearly defines the organizations that I think are with us in this session today, because you would have registered in a different country, not it may be more than one country, but importantly, you have also operations or activities that you are undertaking in this country here. So that means you just coming in there to get a certificate of registration as an international NGO. But importantly, what makes you international is because your certificate of incorporation was done in a different country or in more than one country. So that becomes important, and this is what differentiates INGO from the national NGOs. Because for the national ones, they are basically local, or they just registered in Kenya, and the operations are in here. But for yourselves, yes, operations here, but your original certificate of registration is elsewhere. But again, to operate here because you seek to undertake activities of the same. And this is how we are able to will be able to distinguish yourselves from, for example, what we call exempt. Next slide, quickly. Now, for the requirements, you'll find that they are almost similar to the ones that we do for national PBOs. For example, there is an application form, proof that it's a legal entity in another country. That one comes from the fact that your incorporation is not really here, so we will seek to see that there's a proof that you are a legal entity in another country. Secondly, the organization's address in Kenya for purposes of the activities here. Then you have a written statement from a representative from its headquarters stating three things. One, purpose, description of intended activities, then name, address, and other information of the authorized agent. That becomes important. But we will go into the details as we start the session. Importantly, we have registration of exempt international PPOs. This has been a recurring question we find. Most of the time for exempt PPOs, there are those that are not actually activities here, but basically, most of the time they are the funders. And they are exempted from having to do the rigor of registration because they don't seek to directly a difference between the two, in this case between international PPOs and exempt international PPOs. One requires registration similar to national PPOs because you seek to execute and undertake activities here. But for the exempt, you don't have to register. Secondly, you are issued with a registration certificate, but for the exempt international PPOs, they're just issued with an operating permit. That comes into play because the core difference between the two is the nature of operations. If you seek to come do the activities yourself directly, open offices across the counties or the regions, then that family places you in the international PPOs. That's why we insist on your registration and a certificate of registration. But exempt in this case, if you're just funding, for example, and you don't seek to set up office and all that, then you don't have a reason to be registered or to require a registration certificate. Quickly, then we also have directly implements activities and programs in Kenya. This is a core difference between the two. But for the exempt, they do not directly implement activities or programs in Kenya. So that is the difference. How you execute and undertake your activities. Those that do them will be international PPOs that will require some sense of registration. Those that don't seek to directly implement, they have their partners, their subsidiary organizations, then they will consider the exempt international. Quickly, then you also have for the international PPOs, they can raise subscriptions or any other form of fundraising in Kenya, because with the certificate of registration, then you acquire the rights, you can fundraise and undertake such activities. But for the exempt international PPOs, you does not raise any subscription or any other form of fundraising in Kenya, because you've not been registered and you're not seeking to undertake activities within here. Finally, requires to maintain an office in Kenya, that is for the national PPOs, physical office. Just as you saw the requirements for registration for the national PPOs and the rest, a physical office becomes important for the regulator for purposes of compliance and to ensure there is always a sense of communication and identification of the organization. But for the exempt national PPOs, they can operate through an authorized agent, and that has been the case. So this is just a summary of the difference, and I'm sure we'll still get questions around that as the session goes. Now, what is the effect of registration? Once you register as a PPO, now this one applies to the segment, the international NGOs. Now, the two of them, one, comply with the obligations of the PPO specified. When you registered, you declared your objectives, so you have to comply with the same. Secondly, you are now eligible to access any rights or benefit that may accrue to the PPO organization under the Act, which things to do like tax exemptions and the rest. Those are the benefits and the rights that you are able to accrue as a registered outfit. Now, obligations, material changes, this is just more of the requirements or expectation, maintaining up-to-date records, filing annual returns, and that should be within 6 months of each calendar year, as well as notifying the authority of any material changes. This one applies to the governance setup for any registered PPO. That one also applies for the ING. On top of that, there is a new addition If you look at the Act, if you look at the regulations compared to the past, as we did the comparative analysis, we say under the new regime, now the PPOs, once you are registered, this is part of the rights and privileges that are that upon coming into effect of these regulations you can enjoy, which is engaging in economic activities, but there are specific riders or points expected for you to engage in the same economic activity. Number one, we've said the same economic activity must have been licensed or authorized by the relevant regulatory authority. Now, this one applies to the nature of the business you seek to undertake. We were giving examples. If you seek to undertake anything within the health sector, let me assume you seek to do pharmaceuticals, then there is a regulator within that sector. And for example, locally here we have the Pharmaceutical and Products Board. Then you have to comply with their requirements for you to do the economic activity. If you seek to open a pharmacy, for example, they have their set of requirements. If you seek, for example, to engage in things to do like any financial in nature, you have a regulator in the finance sector, CBK. If you seek to do digital financing as an economic activity, then you have the CAK also there. CBK will be on one part of the finance bit, but you also have the Communication Authority of Kenya by virtue that it's with the digital space. So this requirement, when you say you are licensed or authorized by the relevant regulator, it means that applies to the nature of the business. PIBORA, or the regulator here, on behalf of the public benefit organizations, does not dictate on the nature of the activity. But as soon as you do the economic activity you do, remember the set of laws and regulations that apply for that activity will apply. Ours is just to ensure compliance. If, for example, you seek to carry out an economic activity within this county, you'll always find the national, the county government asking that you register with them, you must have a permit and rest, fire policy. Now that's why we say compliance to the respective regulator depending on the area of activity you've picked. Number two, we have it is in the best interest of the organization. They must be just, this is more or less like a procedural requirement. Let's just prove that whatever you do is for the public or for the benefit or is in the best interest of the organization. Importantly, it applies prudent financial and business practices. This is just more or less like a compliance requirement. And finally, the proceeds are applied to the public benefit activity. This is a rider that was really critical and we kept insisting to all stakeholders. When you undertake an economic activity, it is not for personal benefit. It is for the benefit of the organizations to further its objectives. Because remember, primarily, you are undertaking public benefit activities. So any funding you have, any source of income you have, has to be 100% channeled to that core objective. And that is where now the regulator comes in to ensure, even though on one hand we give you the freedom and the reason to engage in economic activity, the process of the same have to speak to your core objective. Because that then means you remain applicable. Because if you are doing an economic activity, then it becomes very profitable. Then you choose to say, no, we've done enough for the society. We've done the good. Our good Lord up there has recorded our good deeds. Now our time is up. It's time to take care of ourselves. Then you step back. 70% or 50% of your proceeds you do for your own benefit. Why then should we still consider you a PPO? You just step out and say, now I'm formally an entity engaging in business. Now KRA should be at your doorstep. Now you guys can deal. We can no longer give you an exemption. That's why we say it must be towards. In some instances, you found or you find some PPOs even seeking to be political parties. They seek to transition. Possibly they have registered a huge membership. Their sphere of influence is big. And the activities they engage in is raking in revenue like no one's business. They say, why don't we convert it to be a powerhouse and become a political party? So that the activity we do goes towards our political activities. Thank you very much. To tell you thank you. Now you're no longer under the ambit of the PIBORA. You're no longer a PBO. Proceed. We have the political parties space. Proceed to the other regiment. So any economic activity you do has to be directly correlated with the public benefit activity that you registered and you execute. So these are just basically the riders that we did. But it's a good thing because now it's more or less like to broaden source of funding so that organization cannot just be made to be a case of just fundraising. They can also be creative enough. Next, quickly, as we finish up, we have cancellation and suspension of registration. Again, we refer back to the Act. The Act normally gives the grounds for suspension. And we've just summarized a few things to do, like failure to comply with constituting documents. Your own documents when you are registered, your constitution. Because once you register, expectation is that you have to comply with the constituting documents. Where you fail, that can be a grounds for deregistration. You also have failure to comply with the law, in any case where you are taking illegal activities, for example. And finally, breaches of terms and conditions of the registration certificate. Because once you register and registration with a certificate of registration, you are expected, for example, things to do with filing returns and the rest are compliance. Now, a few other things to do with making false representation to the authority. When investigated upon and you find that it was false, you declare to execute one set of activities, but in real sense you just affront and doing other activities, then that becomes a ground. Finally, ceasing to undertake public benefit activity. This is the holy grail. Why are you an organization? Why are you a PBO? Is because you undertake public benefit activities. Failure to do that, then you don't, you cease being considered a PBO. So these are just grounds for cancellation or suspension of a registration certificate. And then you also have recognition of forums and federation of forum. Now this one speaks to the issue of self-regulation, as we were speaking about. In this case, a forum brings together PBOs, and we've said that under the regulations, 10 PBOs can make up a forum. What then becomes important about this, within a forum you can set your own code of conduct. You can be able to set up your rules of engagement. That means the regulator has moved back, allowed you to self-regulate within the forum that you've set up. On top of that, there are a bit of requirements needed. For example, you have to engage in related activities with similar objectives. If you belong to the same sector, let's say you are PBOs within the health sector, then it may be easier to band it together as a forum and have your set of rules that can be able to self-regulate or be able to give more or less operating procedures for the PBOs within that particular sector. So we say you have to engage in related activities of similar objectives. Finally, name, search and salvation is just a requirement, just like registration. Because this is recognition has a similar requirement as registration. Secondly, we also have all those requirements, as you've seen, almost similar like registration. Name, reservation, application, prescribed free documents, copies of certificates. These are the generic, and you share with the documents that you have with you. And then secondly, we also have federations. Now, once you have registered a forum or you have your forum recognized by the regulator, 5 of those can come together and form a federation. This one applies if you have a huge number of organizations within a particular sector, and that has been the common norm. So you may find these are like 50 PBOs, because if 10 made one forum, 5 forums would mean 50 PBOs, and in that case, then you're allowed to register or to be recognized as a federation. Again, the requirement is the same as that one for the forums. You have to engage in related activities. The requirements you will find are similar to the registration of a forum. Then we have dissolution and deregistration. Dissolution is where you are doing it voluntarily, and we've given some of the requirements. For example, 2/3, you can voluntarily agree to dissolve as a PBO. And in this case, 2/3 of your members adopt or approve. And then you also have the resolution being accompanied by those particular requirements, certificate of registration, minutes, and results for the voluntary. Now, this one applies to yourself. Just like a company when it's voluntarily dissolving, you have the similar requirements. Then you have the registration. It can be done by the authority or by operation of the law, in this case, a corporate. Now, for the authority, what could be the grounds? As per the regulations, we try to set a few: failure to comply with the act or regulations, involvement in illegal activities, contravening any other law in Kenya, and failure to undertake public benefit purpose per year. This one has been a concern in most of the forums we've been, and we want to hear your opinion on number 4. Failure to undertake public benefit, the time period. What is your view of the same? Upon dissolution or the registration, there's always a question of assets and liabilities. Where do they go? Now, this one is critical, and the regulations has tried to capture the same. What are the requirements upon cancellation, the registration or dissolution? The following: 1, you have to notify the authority. Secondly, there must be an identity of the PBO to which assets should be transferred to. So there's a right of first refusal that if you seek them, for example, if you're dissolving, if you're being registered, then a different PBO can be identified where assets can be transferred to, because it becomes important to safeguard the same. Lastly, we have provided the authority with a list of all the assets and liabilities, which then helps or makes it easy for a trail of the same, so that if you nominate a different PBO, then it can be seen that the same has been transitioned or has been action appropriately. Summary then, These were the benefits we feel that would be critical. It's a buy-in. It's more or less like an expectation upon the enactment of these regulations. What are the benefits that we think can accrue of this? Number one, simplify the registration process. As you've seen, the forms all clearly provided for, and the regulator has promised that for them, every single thing will be automated. So at a click of a button, and with the forms clearly provided, it now no longer becomes a pressure of a really tedious process. No, it becomes a simplified decision process. Secondly, internal and external review of authority decisions. If you look at our regulations internally, there are provisions and mechanisms whereby whatever decision the regulator has arrived, for example, if they have, for example, suspended your license or suspended your registration, internally there are provisions where the same can be challenged. Over and above that, a tribunal, and I can report authoritatively now that the judiciary has set up a tribunal, there's a tribunal to challenge the decision of the regulator. And the mechanisms, or the judicial mechanism, I hope you understand. You start internally, you can raise the complaint directly to the regulator. If dissatisfied, then you proceed to the tribunal. If dissatisfied, the High Court, and the child goes all the way to the Supreme Court, judging by the nature of the public interest, because Supreme Court deals with matters that are of high public interest. Then you also have better charity sector industry standards, which in this case, the regulator just tries to ensure that everything is up to date. And that's why you saw us trying to compare the Farm Act and the current Act. And you find that the regulations as well as the Act in play tries to ensure that we are in tandem with the current policies. Then quickly, more sustainability through economic activities. This one mostly applies to your downstream organizations where there's a cut of funding. You would expect that with the economic activities, they're in a better place. Over and above that, now that international NGOs also partner with the local NGOs and the PPOs, as you've seen how the funding space has been fluid, every time there's a change of policy or change of government in the Western capitals, who are the predominantly funders of these organizations, if you have organizations already undertaking economic activities, the same cushions disruption within this sector. That's why we say these regulations tries to bring in what you call sustainability. Finally, greater transparency and accountability. Once it is clear how we report, once it is clear how we are supposed to be accountable, once it is clear as to the timelines, then transparency becomes easy. One of the requests or the things we've been encountering as we go out and engaging the stakeholders, you find two sides of the divide. You find also some of the organization says they are taking advantage of and the rest, but at the same time you also get the organization says the difficulty that we always get to ensure compliance. Now this one with the regulations in place, we're trying to ensure that accountability and transparency becomes core, because everything is above board and within and defined by law. If everything is defined by law, then you don't need to struggle. You don't have to, you don't find difficult in ensure that I'm compliant and all our activities are above board. So this particular set of regulations tries to achieve the same. So with that, you feel that we've been able to take you through just a little bit of what the regulations are about, speaking of the Act, and then becomes easy for us then to engage. This becomes the most exciting one, interesting part, where now my responsibility now becomes basically to facilitate, to get your points. This is a very small crowd, compact, warm, cozy. We have 2-3 microphones. If you have any comment that you seek to give that applies to us, or the set of regulations that we've set to play, I would wish them to invite. And if you have a concern, if you have any question for the regulator, I'll be taking 5 to 10 comments. Then the regulator can be able to answer a few of those. Any questions, any concerns that, especially on areas of practice, with the new set of regulations coming into play, with the Act as is, any concerns, any practice areas that you feel, I would be happy to be able to, after, we can do 5-6 comments, any proposition, any questions, they'll be at play to be able to answer. So with that, let me now open the floor for the plenary. Just a round of applause for the facilitator. Let me call upon my colleague Victor. We'll be able to tag team with my colleague Victor to take the facilitation. Just want to take a few calls as he sees through that. Welcome, Victor. I hadn't introduced him as a member of our consultancy because he was not yet here, but he's here with us. So we'll continue with him as we take. Where are the microphones? So we have a microphone here, maybe from the station. So that if there's any concern, any question from the other side, we can bring it up. Carry the floor is open. So we'll start with our candidate here. And sure you give your name and the name of the organization you will represent. Well.
Thank you. My name is Annette Mogi. I'm the head of finance and support services at Grand Church Group. I have several questions. So, and it relates to the regulation. So the first one is the notification of material changes in applicable. So I've noted that the fee is 15,000, but if I'm not wrong, checking from the NGO coordination group, the processing fee to change officials, for example, is 4,000. Is that right? Or the fee triple? So should I answer several? So should I ask the several questions or one by one? Okay. All right. So the second question is enhance sustainability through limited economic activity. So first, this is great, especially for our national implementers, that's the government organizations because of sustainability. First is that percentage, because maybe we need to be clear on that. At what point do you know that you're making, is it 50%? At what point do you know that you're making more profit than you had the activities? And then have you synchronized this with KRA? So, because you can implement economic activity either directly or through a subsidiary. So a subsidiary is easy, because then they find annual return, but directly, what are the conditions for this? Are they, what is that income be treated as? Is it deferred income? Does it go back to the organization? Have you worked with the area to make sure that it is not taxed? The third question, section 22 of the condition of a forum, you said proof of geographical spread of the forum. In one of the engagements that we had, there was geographical, as to how you can form a forum. The other was thematic area. So could we have more clarity on that, where you were saying maybe you would have proof of geographical spread or proof of the same thematic area or something like that? Because some of us like to form a forum because of the thematic area, not necessarily the geographical spread, or maybe you could clarify what that means. And then the last one, I'm sure you probably had of this question in other forums.
So I think for the benefit of our rapporteurs, he says what will be the implication, judging by the judicial findings as well as position on the Act. How does that then affect this particular set of regulations? That's a good one. Maybe we'll give the microphone. Okay. Then I'll come to you.
Yes. Maybe we could stand up. Thank you.
I have 5 questions. Is that okay?
Very good.
Okay, I'll try my best. Okay. Okay. First of all, the question around forums. I know there's a facility for recognition. It would be good to get clarification on whether that is mandatory or voluntary. And also, is there a possibility to lighten the bureaucratic requirements to be part of a forum? You know, forums exist everywhere around the world, particularly in humanitarian development contexts. And I've never been part of a forum where we've had to submit our registration documentation and various other pieces of paper and so on. Bringing that requirement will be a barrier to membership. People will be unwilling to participate, and we'll find that it won't be as representative as we would expect. So that's number one.
I think for benefit of masses, the question is whether forums are voluntary or mandatory. Proceed.
Yeah, and can we lighten the paperwork required to join one? Number two, it's come up already by Annette, but it's about the annual returns. There is a contradiction in the documentation, and I'm sure that will be clarified, but also clarification. Is it after the calendar year or after the financial year? Because that varies for a lot of us as well. So just make sure that when we clarify that is given. Number three, and this came up in the last comment. It was about the High Court petition number E519, and this implies, from my interpretation, that NGOs that are currently registered under the NGO Act will be automatically bestowed registration as a PBO. Now that's an interpretation, but it's good that I think that's a very important thing for us to discuss today. Based on the High Court resolution, all of us are registered. Yeah, so if we are, as NGOs registered today, automatically bestowed PBO registration, that clarification would be very, very important for us to discuss today. And if so, if the answer to that is yes, we would be neither an international or a local, we would just be a bestowed PBO. So yeah, trying to understand that I think will be very helpful today. Okay. Number 4, fundraising activity. I know that if you're an exempt PBO, you're not allowed engage in fundraising activities. I think we need to be a little more specific on this because regional offices are engaging with regional donors, and we do fundraise for regional countries and also for Kenya, but through the home offices in the donors that are in Germany, USA, etc., etc. We need to be very specific on what fundraising activities are prohibited. Is it specifically about receiving the funds directly from the donor to the Kenya office, and it has to be routed through our HQs? That's okay. That's just a clarification that needs to come out. And finally, direct engagement with beneficiaries. Again, for exempt organizations, you are prohibited for engaging with beneficiaries. We might need to be a bit flexible on that. When you look at non-programmatic engagement, like monitoring, evaluation, compliance, auditing, sometimes that will need to be done to engage with the people we're working with on the ground. And that would be in violation of those rules, even though it is not programmatic. So I think that would be useful as well. Thank you.
That's a very good observation, and I'm sure the regulator is listening. They will be able to clarify that. Thank you very much for the questions. The person on the group.
I have a few questions. And I would like to start with what John was saying concerning the beginning of registration and the registration itself. If you look at paragraph 5 of the schedule, and I think it's also on that, it provides for things. Existing entities or users they are giving a year I didn't see in the regulations a process for registration of those that were already registered. There is an indication of this registration, claims, and constitution, and records, etc. So that in itself need application from the authority. Obviously, the authority has come and gone for people, May last year, this year, that really was the period. None of us would get them to be compliant with that provision. But so that's the first one. The second one, excuse me one second. The second one is to the cancellation and suspension of registration. I like what you said about the already not being high-handed or heavy-handed kind of thing. Sadly, I see that in that position here. The Act, sections 18 and 19, certain provisions concerning cancellation and suspension of registration. I was expecting to see the argumentation of those in the regulation. Let me give you an example. The Act provides for finding an organization that has failed to comply with our regulations. These regulations do not have any process or provisions concerning finding. And presumably, you find an organization that has the infraction is so big as to take the draconian measure or suspending or canceling the registration. I don't think that here, so that needs to be maybe provided for. Suspension, again, for it to make, to speak to what you just said about not being heavy-handed, and needs to be motivated. Needs to be for certain duration. You're suspended for 6 months until you do X. And I don't see that here. Just a straight suspension. Then the Act, Section 18, provides for notice. Before any of these actions are taken, finding, suspension, cancellation, and minimum of the 3 days notice to correct the infraction. If the notice doesn't have, I have thought maybe what we have is 15 days for an easily correctable infraction, 30 days for another one. For example, if you do not have a chair or you do not have to, you need to call an AGM or an EGM, you can't call it in 15 days. And you can't do it correct. So I was expecting at least to have at least 1 minute on that, so that we are giving you so many days to make this correction. And if you do not correct, then you cancel or will suspend. So that's how to enable compliance rather than police and crash the lack of compliance. Again, those two sections also provide for identification of the decision of the authority to define, suspend, cancel. By the way, this is before we go to the Bible. So the authority has you have space to go and say, hey, I think you misunderstood my documentation, this is what I have. So that would you review this decision? Again, the regulation should have more on that process. What is the nature of the application for review? How long do I have to apply for this review before the decision becomes final, etc. So again, we really need due process to be authorized by the regulation. About the things that the tribunal for the tribunal, I have another comment with regard to Section 18, restrictions upon suspension. Once people are suspended, nothing else. You cannot withdraw any funds from bank account, you can't do anything. However, there are continuing obligations during the suspension. This could be legal obligations, it could be statutory obligations. When you have these provisions that are not accepted, and the people simply pass. And if you pay the police, it was on the 28th, it was suspended. And normally there is Saturday on 29th. What happens to the employees and the lawsuits that will come from the employees? The necessarily the PPO is not complying with this legal obligation. So I think there ought to be a mechanism to allow suspended people to discharge this existing operation that people and legal obligation. Even if the organization want to score a status, but there has to be some form of operations that are not, for example, let's say the capacity of the organization and the system. I suspect that will be misuse that this was supposed to cure. And finally, and I think this has been mentioned by the George Ministers, is to do with the filing of the returns. There is a lot of contradiction there, but what I was saying in my suggestion is to provide for 6 months after the end of the financial year of the PPO. The reasons are many. One is the most important, is that most of these PPOs have got affiliations. And these applications have got a certain financial year. It is better to have a consistent year and application rather than to have different, and that will make it easier to comply. The other thing is organizations audit at the end of the financial year. If I'm to file an account by that start of March, and my year ends on that day of June, and my audit is not due by start of September, how do I do it? Yet I'm supposed to be financial information or the account. So, that's the system we have expanded 6 months after the end of the financial year. It's what our business, and I think it makes sense. Thank you.
Thank you very much. And I want to also I really appreciate the richness of the contribution because there are so many practical and something to consider. Our rapporteurs have been, their heads are not enough, just trying to tie out everything. Just one more comment, then I invite myself, then I come. Let me first handle the set of comments and concerns, then I come to the second row. So let's start with the first.
Thank you. My name is Rose Kanana from Refuge.
Come again?
Rose Kanana, Refuge. So I'm looking at the second schedule forms.
And maybe just a bit for our tech team, the online people are saying the sound is unclear, so try to sort it out. Proceed. Okay, you could stand so that. Proceed.
So I'm looking at the second schedule, and that is under forms, and specifically going to form 3, applications for bestowment of public benefit status. And just to be extremely clear, and members, a bit of clarification. For example, if you look at page 26, when it comes to the level of detail, and a board member is not necessarily residing in Kenya, and the requirement also includes a submission of PIN. They are not a board chair, they are not a secretary, they are not a treasurer. What would be the alternative for the Kenya rating submission? Thank you.
Thank you. Maybe 2 more here, so that when I go to this, if they come to you, finally, sir.
My name is
Thank you.
Okay.
My name is Nelly Shongo from Kodes. And okay, my question is around IDO. There are clouds or a point about doing direct implementation. Yeah? And I think there is need to add more content to that, because sometimes when we talk of shifting the power, and we are some INGOs also they sub-grant to partners, yeah, local partners, organizations, and they don't do exactly direct implementation. They do monitoring, they manage the program, but they are not working directly with communities. So it is important that we take care of those INGOs also. I think my second point is about a clarification. When we talk of when you are registering, and you are required to have been registered for 3 years in your source country, what is the reason that you thought it fit to actually apply a 3-year registration? Maybe if there are new agencies coming up, why are we thinking of 3 years?
Thank you. So yes, okay. Yes, take that.
Okay, good morning. My name is Janet Babalu from Christian Aid. So my question is how the regulation is mirroring with other requirements from government. And my example is there is a requirement from the also the president that if an NGO is to have a regional hub in Kenya, it's given agreement by the ministry. How is that correlated with the current administration, especially for organizations that will have a regional hub in Kenya? So how is the connection between requirements from one ministry on the other on such an organization? The second one is on federation or forums. I think since these new regulations came, you see how many organizations have federated already in various forums, which has brought a lot of changes in the sector. And it's because even the current regulations are not giving a guideline or process of formation of this federation that will represent the PBOs now at national level. So what has been the proposal, and how are we going to fit some of those challenges that are coming out around that? Thank you.
Good morning. My name is Maria. I'm the regional director for Action Against Hunger, and I have a very practical question. I think most of the questions were already said.
Maybe you write for us the name of organization because they put it great.
Action Against Hunger.
Action Against Hunger.
Regional officer. Mike, a little bit.
Okay, proceed.
So,
Action Against Hunger. Proceed.
I want to understand for the two situations, the PBO International and XM international PBOs, what is the requirement for the boards, the local boards, and also understand better what exactly is expected for that agent, registered agent in both of the cases, and what exactly is that necessarily to be somebody Kenyan national, need to be somebody that have residency here, etc.
So thank you very much. We've had really good round of questions. I would want to invite two people that I didn't introduce. So Chief, please come. And Victor, I'll just introduce them. Please turn down. Because they are part of the team. Some of the questions, I'm sure. Just name. They are the senior consultant that we've been also working with.
Good morning. Good morning. My name is Henry Chino, and I'm a consultant with the team.
Good morning.
with CNK Advocates LLP. I'm part of the team that was called to assist in doing the draft regulations, and I'm happy to be here to be able to engage with the primary stakeholders who are the consumers of the PBO Act and likely consumers of the draft regulations. So we're happy to be here, and we'll be excited to get your feedback so that we end up with a more refined draft. Thank you.
So for the team, especially when you see Mr. Ochido, I was insisting for him to come here today because he's previously worked with the regulation. He's a senior consultant in this, and some of the concerns that you are raising are part of the things that we have to grappling with and ensure that at the end of this session, nothing will be left to chance. Massive. Forward. So once she's able to answer the concerns and the clarifications, I'll come to the group now, and then we will continue with that. Welcome.
Thank you. Thank you, Bishop. I hope you can hear me. Right. Good morning, everybody. Good morning. My name is Mercy Soy, and I work at the PPRA. I'm an advocate of the High Court, and it is a pleasure to be here before you today to be able to respond to your concerns and to be able to engage with all of you as we purpose to develop a document that is befitting for the regulation of the PBO space. Okay, I will start with Annette from Dan Church Aid. And you raised a question about section 22 and a clarity on the formation of a forum and what are the considerations that are made in order to have a forum established. So there are several considerations. You can look at the thematic areas in its entirety and say that because we are in the health sector, we are therefore going to form a forum, enter into a recognition agreement with the authority, and thereafter be recognized as a particular forum. The other option would be geographically or regionally, and I would like to also say that the options or ways of establishing a forum are not limited. They are not limited only to those. There could be others that really, as the authority, we have not established that there are ways in which a forum can be formed, and it would really be good to have those ideas come out from this meeting so that we also always moving forward have those considerations, that those are ways of establishing a forum. And then, still on the issue of the forum, Keith Doyle, you had asked about whether it is mandatory or voluntary. Joining a federation is voluntary. It is not mandatory that all PBOs must be members of a forum or must be members of a federation. It is voluntary. It is based on the PBO itself to decide how they want to associate, who they want to associate with, and overall, the Act requires that every forum do come up with their own code of ethics, standards, and guidelines. It is not for the authority to determine these guidelines. Why? Because it is a voluntary move, and the aspect of freedom of expression and association cannot be controlled or managed by the authority. So as a group, once you have established this particular forum, then you will have your own guidelines, your standards, your codes and ethics that you have developed for purposes of self-regulation. because the idea is for you to develop standards and codes that are actually promotional in terms of self-regulation. And when we look at the act, there are certain values that the act lists down for consideration when developing these ethics and the standards that guide the formation of a forum. And then evidently, there is the issue of the financial year, and this was an apparent error that we actually noticed when we received the document. And once we noticed this error, we could not then do amendments at that point in time, but it is actually the first thing that we are going to change and address. So, filing of annual returns and audited accounts shall happen within 6 months after the close of the financial year of the organization. So I think it is really important that that clarification is offered. And then there is the pertinent question about the High Court case, and the other question that has stood out is that of the transitioning of already registered entities, and what the process is, what the authority is doing about it, and why that has not been provided for in the regulations. So I'll start with the issue of the High Court case. And states that most of us are aware of the history that has been around the PBO Act. And when this act was actually assented to in the year 2013, there was a realization that some clauses were contradictory or inconsistent. The move that was taken by the ministry at that time, which was that of devolution and planning, was to establish a task force to develop amendments and to recommend amendments to the Act. The task force comprised of the government agencies, the NGOs themselves, civil societies, and other pertinent stakeholders. What thereafter followed is that after the task force had finished its work, and right before the adoption of the amendments by the task force, we had 2 court cases challenging the amendments to the PBO Act. These 2 court cases were before Honorable Justice Onguto and Honorable Justice G.V. Odunga. And at that point, the court directed the then Ministry of Devolution and Planning, where the NGO board, the defunct NGO board, was placed, to implement the Act as it is. That was the court directive, that the Act must be implemented as is. It must be operationalized, and then challenges that are seen to be emerging in the Act be reviewed, addressed, and amendments should follow later. Because of this ruling, this Act was put in abeyance from 2013 until last year, where the government had made a commitment that it would operationalize the PBO Act, which it now did. Upon operationalization of the PBO Act, we revisited the court issues, And these were the particular 2 court cases which directed that implementation of the act must happen. We must examine the implications of the act, and thereafter, from a practical point of view, call for amendments to the act. So what basically the authority has been doing is to comply with what the court directed back in 2013. So moving forward, having complied with that provision, we had yet another court case challenging the operationalization of the PBO Act and some specific clauses in the Act. So we proceeded with the matter in court. Judgment was issued, and the judgment was to the effect that there are particular clauses in the Act that have been declared unconstitutional, including issues to do with board composition. The same court issued orders against its own judgment. That means the same court took a back seat and set aside its own judgment. Where does that leave us at this point in time? It leaves us as the authority to continue with the implementation of the Act, because the same court has issued orders against its own judgments. We are also presently in the Court of Appeal, and under the stay orders, then we are proceeding with the operationalization of the PBO Act. Now, for avoidance of doubt, this process of development of regulations was not a subject in the court case. It was not challenged in the court case, and therefore, there is nothing that bars us or stops us from continuing with the public participation and the development of the regulations. Now, I want to put across a food for thought in this matter. The Court of Appeal, being an independent body, will make a decision. It may decide to agree with the High Court and say, indeed, these provisions should be deleted and amended. They are unconstitutional. It may decide to agree with the High Court rulings of 2013 and 2014 to say, why don't we operationalize and implement this first? That is the current position. So the food for thought that we have is, should the Court of Appeal then require us to delete some of these provisions that they had already declared, we will delete them. If it upholds that we continue with the implementation, then we will continue with the implementation. But it would be quite a sad affair if we take a backseat and do not interrogate and engage with these particular provisions. Because then if the court allows us to continue with operationalization, it will be disadvantageous to all of us for having not interrogated these provisions. And I want to, in light with that, say thank you to Mr. Kimani of World Renew, because you brought up very nice points with regards to the process of suspension and the fines and the deregistration. And while you were giving your comments, I was able to quickly look at the Act. And the Act gives provisions in terms of timelines. When are you required to file for the appeal if you have been suspended? What are the timelines? What are the notification processes? I, however, agree with you that we need to beef up this document in terms of the processes of how do we fine, what are the considerations, what are some of the offenses that call for a fine, those that call for a suspension, and those that call for a deregistration. So that, moving forward, once the court concludes the process at the Court of Appeal, we are able to interrogate and see, are we still allowed to suspend and deregister? If we are still allowed, then we will have done justice to this document. If we will not be allowed, then what we will simply do is to delete those provisions, and we continue with the process of facilitating the PBOs in the country. Now, with regards to the process of the transitioning, it has not been captured in the regulations, and this is by legal design. You realize that the transitional provisions are found in the schedules of the Act. Upon wide consultation with the Office of the Attorney General, the advice that we received is that we cannot provide a transitional provision in the regulations. And secondly, this process is expected to be a one-off process. Because, for instance, 10 years from now, we will not require this process of transitioning from NGO Act to the PBO Act, because everyone will have transitioned. So essentially what will happen is that it will be an administrative process. What we need to do at this point in time is conclude on the regulations, then give out administrative guidelines on how already registered entities are going to transition. And it will be very seamless and easy because, one, we will need your updated constitution. Reason being, if you are changing your financial year based on the new provision of the Act, if you want to engage in income generating activities, for example, and then you wish to incorporate this in your constitutions, if you would like to borrow parts of the PBO Act to your constitutions, then we will need an updated constitution. We will also need an updated board membership so that as we are doing this transition, we have the proper and up-to-date documents. And somebody will ask, what exactly is transitioning? What it means is the PBO authority has to maintain a register of public benefit organizations. At this point in time, we have a register of non-governmental organizations. The Act came into place, and all entities previously registered as NGOs became and qualified to be public benefit organizations. Now, administratively, the authority must have an accurate and up-to-date register of public benefit organizations. The Act provides 4 ways of registration of entities. Previously, the NGO Act only had 2 ways, national and international. Now the Act introduces exempt organizations, and it also introduces bestowment of the public benefit status. That means the register of the public benefit organizations that we hold must be accurate, it must be up to date, so that we enter entities into this register accurately. And that is what this transitioning process actually really means. It does not mean a fresh incorporation of an entity. That is not what registration under transitional provision means. Registration means being entered into the register of the public benefit organization. So it will not be any fresh incorporation of an entity. And then there was another question about the appointed dates of transitioning, which has expired. Now, when the PBO Act commenced on 14th of May 2024, the transition period was for 1 year. This year, on the 13th of May, the Cabinet Secretary extended this transition period for a further 1 year. There is a Gazette notice out to that effect. So this transition process now is still open up to May of 2026. The reason for that is because we realized we are not going to have regulations in place on time, and then for us to now administratively carry out the transition. Because those two processes must be carried out in order for us to do what? To do the transitioning, and then also to be able to carry out fresh incorporation and fresh registration as per the PBO Act. So based on that, really we are in good standing because the extension up to May 2026 is quite favorable for all the entities that we regulate and also for the authority, because we are able to put everything in order and to be able to facilitate the organizations. You will allow me to sit down, and I will invite Mr. Isaiah Sang to respond to other questions that have been raised, and these are particularly operational questions. Just to recap, these are the questions about direct implementation or not. What does that mean? Okay. And the issue of the exempt organizations, the issue of regional offices, and I know that is also an area of keen interest, so I'll ask Isaiah Sang to step in for that next session, but we are still here, and thank you very much for listening to me. It has been a pleasure. Thank you.
Thank you, Mercy. Let us appreciate Mercy for those insightful. Thank you. So I'll address issues of how they were asked. The issue of sustainability from Mumbi. The Act provides for entities to engage in economic activities. Then you ask the question, at what point will you know that exceeded profit making and all that? So ideally, what will happen is that the PBO itself will have to register another entity to run the commercial aspect of it, engaging in that commercial activity. That entity will run its life in terms of its activities, its commercial engagements, and then at the point of now closing its books to now declare the profits. And as you have said in the Act, the profits will be given as donations to the PBO to enable it further its objective. So if it's able to achieve 100% profit in a year, the better. Yeah, it's able to achieve more than that, the better. So that it's able to donate more and further the objectives of the organization. In terms of synchronizing it with the KRA, yes, the legal entity now, the business entity, will be declaring its own documentations through its own independent bid. That means it's a separate entity. So it will have its own obligation as any other legal entity in Kenya that is engaging in economic activity and able to declare its profits, able to declare its books of accounts, purposes of taxation. Okay. Matthew has handled the issue of the forums in terms of recognition. In terms of its application for recognition, I think that's covered in the regulations very clearly. So there will be issues of the numbers, what they need to meet in terms of the condition set, and then apply for purpose of recognition. And then that the same recognition can now be used terms of registration, application for its membership at the federation level. So it can be used at that level. Then in terms of its composition, forums can be formed in terms of geographical space or thematical space. So in terms of geographical, if you are PBOs operating in Nairobi County, you can decide to form a forum, that particular geographical space. If your federation, if you are a PBO organized in terms of, let's say, health sector, you can decide to form your own forum, that particular health sector, and establish your own conditions, the rules that govern your space, purposes of self-regulation. And then there's been made clear by Mercy on the issue of annual returns. It's 6 months at the end of the financial year. So the issue of the 3 months is not applicable here. Edwin asked the issue of merger of two organizations. I think I'll request the children to handle that if you are able to address that. Merger of two entities, has it been described in this act, and how it would go going forward. The issue of fundraising and the issue of local activities. This is by Keith. Yes, this is a very important question. The Act talks about international NGOs, PBOs, and exempt PBOs. And it gives that condition that exempt should not be allowed to fundraise locally. Fundraising locally. So within the borders of Kenya. If there are exempt entities that are already existing in Kenya and they wish to fundraise locally, what happens? You see that? Because they are regional entities which can bid for funding from other prospective donors within the region. So, in my view, I don't know if this will stand. You allow the locally existing entities to fundraise and leave the regional office out of this space. So there is fairness and there is, I don't know if it's giving the Kenyan entities equal chance to also bid for these resources. For the regional offices, they can bid from other regions and even globally. So they're able to bid for those ones and allow the local entities to bid locally. Is it fair? Yeah? Is it not fair? Okay. We will get more feedback on that. We get more feedback on that and see where do we have a balance. Okay? There's the issue of restrictions upon suspension. That's a very interesting one. At the point, the Act was not clear on what needs to be done and what level of restriction can be applicable at the point of suspension. So, yes, I agree. We need to have more clarity in the regulations on to what extent can the authority impose suspension, to what extent can the PBO be allowed to operate or even access some of its facilities to enable it to deliver on its mandate, and what Kimati was talking about is other legal obligations. So we need to maybe make it more clear in the regulations. And then there's a question on if these regulations is in compliance with other government agencies who have other conditions. So, one, the regulations and the acts are supposed to ensure that there is a legal entity in existence. So we talk about the entity that has been incorporated and has been given its legal existence in Kenya. If that entity wishes to have other agreements with other government agencies, then that will now apply separately. Okay? For example, we have seen agencies, PBOs already existing, and going ahead and signing MOUs with county governments. You've seen those ones. You have seen agencies that are already existing and going ahead and signing MOUs with ministries. That will be done on a separate level. So it will be a legal entity which is a PBO and a government agency signing a level agreement between those two parties. Otherwise, the Act doesn't restrict, doesn't limit collaboration. In fact, it gives more room and now clarity in terms of collaborations between PBOs and government agencies, PBOs and county governments. There's a question on governance for local boards and especially for the exempt entities. So for the international entities, the Act provides for establishment of the boards for the international entities. For the exempt, it provides for the agent, the agent, yes, where the entity can be established and provide details of the agent under which that agent will be the contact person. Okay. Again, I think I've answered those ones. So, I don't know, Mr. Chido, you'll be able to answer the issue of the.
Maybe Mr. Chido, any comment on matters, exempt entities? Please come. And then you also have Victor Sheila Del Bertan. Please come.
So the law does not provide for mergers. So that is difficult to provide for mergers. So if you want to merge, then what you need to do is one of the entities will have to dissolve itself. And then in terms of the Act, provide that it will then evolve its assets or hand over its assets to the other entity. So that's the only way you can do it. But specifically, there's no provision for you to come together in terms of merge. Does that make is that clear? So, sorry? Oh, okay. So, yeah. So the Act does not have a provision for two organizations to merge. So if two entities want to merge, one of those entities will have to dissolve itself, and then as part of that dissolution process, it will propose that it wishes to hand over its assets and its program to the other entity. Is that clear? Yeah, so there's no merger, there's no provision for a merger.
Maybe also you could comment, there was a question about authorized agents and exempt entities. How do you identify and distinguish? That needed also a bit of clarification. How do you identify, because I think there was a question on identification of exempt vis-a-vis international NGO, and then importantly for the authorized agents. The question was, must it be a Kenyan citizen? Can it be a non-Kenyan? Like, what are the parameters around that? Then there was an important one also that I picked. For the international NGOs, I've realized that there's an overlap here. You find, for example, when there's a struggle to distinguish between international NGO and exempt, is because of Nairobi being a regional hub. So that has been recurring. How do you draw the nexus, especially on this part, Mr. Chido, when you are seeking to identify? An organization can come and say, yes, we are here as an exempt, but remember also, we are here with our regional office, other countries referring to us. So how does the regulator try to draw that nexus? And then I think I'll come to clarify. There was a question raised about, how far the limits for an exempt in terms of things to do with monitoring and evaluation. Let me answer that. But for these ones, please, you can answer.
So the first one has got to do with the agent, isn't it? So I think the Act is very clear that the agent must be a Kenyan. And the reason being that we want, I think the idea was to have somebody in country who can be held responsible for the activities of the exempt organization. Because as we know, because as is clear, there will be no representation of the governance body in Kenya. Because once you are registered as an exempt organization, you will provide details of your governance body in your home country. But in terms of now, the person that the regulator can deal with on a day-to-day basis, that has to be somebody who is now resident in Kenya. So the agent has to be a Kenyan in terms of the law. I hope that answers that particular question. The regional hub, well, so my understanding is this. So we have two different types of international organizations. The first one is the one that comes to Kenya and says, you know what, I intend to raise money, I intend to implement activities directly. So if that is the case, then you'll be required to incorporate, okay? So once you incorporate, you'll have a local board of directors. So effectively, you'll be regulated as if you are a national organization to as far as I can tell. Then there's other one, which is now the exempt organization. So this one says, you know what, I'm already incorporated elsewhere. I do not intend to implement activities directly, and I know that's one, the issue of what constitutes direct implementation, obviously that has to be clear. Then the other one is that we also do not intend to raise money in Kenya. In that instance, then you are saying, okay, we do not need you to incorporate. You will give us a list of your directors from whatever country you have come from. We'll allow you to operate under a license in Kenya. Now, the act is very clear that an exempt organization cannot implement activities directly from Kenya in any other country, or implement activities directly in Kenya. That I think should be clear. There's a lady. So, sorry, the act provides like this: that if you wish to, that if you are an exempt organization, you cannot implement activities directly in Kenya, or use Kenya as a base to implement activities directly in any other. That's what the law says. Okay, and let's go back to the history. Let's go back to the history of how this came about. For a long time, we had international organizations coming to say that, you know what, we do not want to establish local governance structures in Kenya. Okay? And part of it was because we do not even implement directly in Kenya. We do not engage with local populations. What we do is we hand over grants, and we provide policy support to other local entities. Okay? So this structure that we are now seeing in the act is not something that just came up all of a sudden. This was a process, and I think that was now the balance that I think the government tried to, in terms of a policy, the position that was the balance that the government tried to bring out. And the idea was that if you are bringing in, if we do not have a local governance structure, okay, if we do not have board of directors in Kenya, we will not then subject you to stringent regulatory requirements. But at the same time, we then cannot allow you to do certain things that will then require us to monitor you more deeply, isn't it? Because if you're saying you don't have a local board here, then at the same time you want to raise money. First of all, you're narrowing the space for local organizations to raise funds. The first instance. Then the other one is you're going out there, you're engaging with communities. So what if something goes wrong? Who do we hold accountable? You understand? So that is the balance I believe that the government is saying.
I want to clarify something. Yes, sir. And I carry forward of what he mentions. The borderline is the activities you undertake. You have an organization that directly engages, deals. Let me give, for example, if you are a charity organization, if you are a PBO within, for example, the education sector, you set up schools yourself. You manage the schools. Now, that is a direct activity. If you only, for example, as he says, you provide grants, you provide support, and that's why I wanted to comment on that opinion, or there was a question here, because I want us now to be practical. If you are an organization that provides grants, you provide funding, Then within your reporting, part of your requirement for providing these grants, you can send in a team for monitoring and evaluation. Let us see the nature of your activity. The nature of your activity is not of charity in nature, but is in line with your task, which was funding. That's why you are going down to the field to find out if indeed your funds are getting to the intended beneficiaries. That is still a common strand. That is not a different set of activities. It speaks of the same format of what you've been exempted, or the basis why you are an exempt is because I offer grants. Let me give, for example, I have worked in a government institution where if you are funded, or some of our programs are funded, nothing stops the donor from coming all the way to the field to ask institution and facilities. For example, they can come with their questionnaires, they can come down with their team, they just want to get a feel. What has been the experience? We have our implementing partners. We have our downstream subsidiary organizations. They have come to offer this particular service. Now we are the donors, or we are more or less like the grant owners. We are just coming to find out if indeed our funds are getting to the direct beneficiaries. Mercy, am I wrong to say that one is not a direct activity? They are basically seeking compliance for their funding. Are we together on that? Is that in order? Have I clarified that a bit?
It's not always revolving around funding.
Yes.
Sometimes it's a regional office supervising country offices.
Okay.
And it's not all about the funding, it's about the responsibility of the regional.
Can we classify all that under monitoring and evaluation?
Yes, roughly.
Because you are monitoring also your line downstream organization. Because you're just seeking to ensure, because you have your set of rules, you have your set of standards within which they're supposed to operate and comply. For example, for the grant or for the program to continue being, there's a set of rules that you've set. So basically, when you come down with your more or less access, people who are coming to assess, you are seeking to just ensure compliance, yes or no? Mercy? I think I'm in. So that is now important, because so that I give you the comfort not to appear, will then be subjecting you to a case of you have to incorporate. So I hope I've tried to give a bit of comfort in that. Secondly, the opinions you give us, or the comments you've given us, you're even giving us more reason now to go back and try to ensure there's clarity so that it is not just left in the gray area. Because I can see from your faces, what you are asking is clarity, so that tomorrow no one knocks on your door and tells you, oh, you are no longer exempt. You are an international NGO, right? So that's what we are trying to avoid. You had a question there. Yeah, please, proceed. Where is the mic?
Still morning, isn't it? Good morning, everyone. So my name is Hassan Abdullah. I work for an organization called Islamic Relief.
Yes.
And I have a few things. First of all, I want to make a comment. We have had this act, the PBO Act, in limbo from 2013 up to today. And I think there's need for us to fast track that process and make it, a legacy of this government, so that at least the PBO Act comes into effect. That's very, very important. I think it's necessary that we also incorporate what the courts have suggested, both in 2013 and also during this time. There were also court cases, and Mercy had already clarified some of those issues. So please make it as easy as possible for all of us to ensure that this act comes into effect. I think that's the most important thing for all of us. There are a few things I want maybe in the act to be considered. For instance, you said we have to register forums or federations. I think we are all registered. We will still all be registered under the act. Please give us freedom to associate or assemble without making us go through the process of registration again, because we are all registered as an organization, and we all know that these organizations are all existing and they have a registration, and they are able to associate as INGOs or as local NGOs or under any thematic area that you can associate, whether health, education, or water. So I think there is need for you to consider that under this public participation, we're emphasizing that we should be exempt from registration of forums or federations. I think because we are all in different thematic areas, and then we can be considered for that. Another thing I just want to also ask is, we have under international organizations, we have our regional offices, and we also have our country offices. And sometimes our regional office may not register because we are all one entity and we live in one compound, all of us. We live in one compound, and we use that one registration to carry out work in the country. So is there a possibility in the act that can be considered? If an organization, for instance, let's say Action Against Hunger or Islamic Relief, for instance, let me pick, or Save the Children, have a regional office within Kenya, and they're using the registration for their country office, is it possible that, can that be considered within the act? Rather than register us twice, you register our regional office, and our regional office has a major role they play. They monitor the programs that we do. They also monitor other countries, yes, but they monitor the programs that we do. They help in the fundraising initiatives for the country offices, and they one way or the other involved in the implementation because they monitor all these programs. So can we be considered as one unit and register as one entity? The other one is maybe you need to really explain what an exempt means. I think it's not very clear to all of us, if I'm not wrong, to all of us that an exempt means, for us what I was considering when I saw it, it's like we are just transitioning from one, from the NGO Act to the PBO Act, and that's maybe what I took as exempt. So can that be clarified? I think it's important. It's important that we clarify. One last thing is I want to emphasize that this act must come into effect. We cannot be in limbo from 2013 to today. It doesn't really augur well. And the government's transition, but I think this act is something that is really key, because the PBOs or the NGOs are a very key stakeholder in this country, because we employ quite a lot of Kenyans and also non-Kenyans, and we contribute to the taxes in this country. So I think there is need. Can we say, I don't know whether the Director General is here, Mercy or Caroline or whoever is here in charge for this occasion, make this a legacy for this government, so that at least this act comes into effect, it's functioning, but we can still amend certain parts of the act in that process. So I think I want to leave it at that. Thank you very much.
Thank you very much. So I want to first go to the team for the second row. We'll take up to 5, 6, let's say 10 comments before we can answer them. But before I can give out the microphone, one clarification, because I want to make it as simplistic as possible. Where do you draw the line between exempt and international NGO? It boils down to undertaking activities of public benefit, what you've registered for, what you are known for. If you directly seek to undertake the same activities within the country, then that firmly places you under international NGO, which will require your registration. The only thing that makes it different, for the exempt, they don't seek to directly implement. That's why they have implementing partners. That's why they have downstream organizations. That's why they have subsidiary organizations that are doing it on their behalf. So that, for example, that's why I'm coming to the issue of self. So that, for example, if I am an exempt organization, nothing stops the exempt organization, for example, to be here to monitor their other organizations that are registered as PBOs to undertake those activities. But where you are above the fray, so that we don't have to bother you, we don't have to come at you and tell you, please comply with us on this reporting mechanism. Because the organizations or the PBOs that are executing on your behalf are already compliant on your part. And as I've used, in fact, the reason I was using the case of funding, the most common in this particular space is grant and funding, because they will just come and offer funding and supervise, but they are not physically or they are not directly involved in implementation. That's what makes the difference. So that line has to be clear. But if you seek to yourself do it, you seek to open up your offices at the regional level, at the county level, you are now seeking to directly implement programs where you as an organization execute those programs downstream all the way to the county or even to the location or the sub-location level. Then you no longer become exempt because you've joined the fray. You are part and parcel of other PBOs, and therefore your reporting mechanism, your requirements will then be as expected by the Act and the regulations. You then have to register. That's what I wanted to draw that line. So most of the time, it's a very thin line that organizations in this space have to make a decision. Where do you see yourself? And the reason why, and I agree with you why these regulations become very important. Once these regulations are in place, even if you choose to be an international NGO, as long as we make registration and compliance very seamless and efficient, then it will be so easy. You can wake up today and say, look, we no longer seek to deal with implementing partners. We no longer seek to deal with subsidiary organizations. Now we want to set up our offices themselves. If, for example, I come from North Rift, and you see we had 2-3 organizations that were handling, for example, a cluster of 2-3 counties. We have done our monitoring and evaluation, and have realized that there is no longer efficiency. And therefore, we seek to directly partake in this. Now, let me use a very good analogy from a business component. You've seen these petrol stations or petroleum dealers, Total, Shell. They can choose to issue license to individual pump stations to execute on their behalf. They'll only come brand, but as to the stock and everything, those are individual people doing it. They just issue you with a license. Then at some point, Shell decided to change their policy and say we no longer seek to outsource. We no longer seek to give licenses to people to undertake our work. We are the ones coming to run those pump stations ourselves. So that right from head office, we are going to recruit people who will be manning those particular pump stations. So they no longer issue license because they don't need any other third party. They are the ones doing it themselves. So just juxtapose with yourself as an exempt international organization. You are here as an exempt. Let's assume, for example, you have your regional hub. You are monitoring for the entire region, Horn of Africa, or even East Africa. So Kenya is one of them. And you have your implementing partners here. So the reason you are sitting here with an office and you have your exemption permit is basically to monitor and ensure that your programs are running, but through the organizations. And then you say, no, Eritrea may be far, Burundi may be far, we can let the subsidiary organizations or our partners to undertake for us. But for Kenya, we seek to cut out, we are ending our partnership or this grant that we have with these other smaller organizations that run for us. We are setting shop here. We seek to implement directly the same programs. We have capacity. We are going to recruit and they'll be our employees. You then cease being an exempt organization. You immediately then wear a cloth of an international NGO, which means then you incorporate, or more or less you register with the regulator as an international NGO. You cease being an exempt. And if you, for example, choose at some point to cease operations and say, we are completely outsourcing and leaving it to other PBOs that are registered here, whether local or whatever, to continue, for us to just climb up basically to issue grants and monitor their programs from up here, then you cease requiring to be considered an NGO. Then you just step back, you become an exempt. So these particular regulations will want to have that clarity. However, the take home from this session, and that's where we are really seeking these comments you're giving us. Let us refine and have clear clarity. I would even ask it be in writing. The comments and opinions that you've given, I've had a few that are speaking to the same. You are at liberty. In fact, I should have started by asking if anyone had a written petition or memorandum, would be happy to take. So help us. Part of the reason we are doing this public participation is to ensure this clarity is absolutely in place. There is no better person who would understand this clarity than yourselves who crisscross the two sides And most of the time, there's an overlapping mandate. Whether you have a regional hub here, which then firmly places you in the space of exempt NGO, but at the same time, some of your organizations also actively have offices across the regions, across the counties. I tend to use regions because at times you find that we cluster our counties into regions. Even how we were doing this public participation, we were clustering counties. You may say North Rift region, you may say South Rift, you may say Lake Basin, you may say Jumuiya ya Pwani, which means it's the coastal, or you may say the northern frontier, in this case upper, that is upper eastern and northeastern. You may say just the cluster of the eastern. So all that can apply. So I'll be happy also to have it in writing, the specific comments and clarifications that speak to the provisions that you feel will give that comfort. And lastly, the comment that maybe now that we've taken in, and I think regulator has taken keen note of it, there's this underlying request, Mercy, this is of importance to the regulator, that we are not looking to come with stringent. We are basically opening our arms where we are engaging and saying, how can we ensure that it's friendly, it is welcoming? Because charity space is not a fighting space. It should be a space whereby these regulations facilitate, make it easy. Because at the end of the day, it is for the benefit of the public. So that some of the requirements expected, and that was a comment I think, as we'll be doing validation, we will be discussing as to how to bring that out clearly. I got this comment, for example, where you say, if, for example, you talk about the requirements on suspension, cancellation, can we be able to specify, like we can, in between the lines, to spread it out, including giving that point that I've taken that is very strong and makes sense is, it does not stop them from executing their statutory obligations. That is no-brainer because it is important. Even though, for example, you may be suspended, it does not mean that your obligations, statutory obligations, maybe to your employees and the rest stop. Those are the kind of the concerns that I think we have to put into place. There was also a comment that maybe we'll need a rethink and we'll now be able to brainstorm. Uchito, please take note of that is the issue of fundraising. How much leeway, especially for even exempt, how can we be able to refine this space on fundraising? Because charity space is about fundraising and it's about voluntary fundraising. So those comments we've been able to take. So I want to give now a chance to this upper side. We'll take up to 10 comments and then 10 or concerns, comment, clarification, and then we'll be able to come. So my colleague Victor. Okay.
So I think in terms of the issue of the direct implementation, if you look at the Regulation 13, there was a bit of a mix-up. So we have two aspects to it. So look at the Regulation 13(2), A, B, C. Okay? Those ones have to do with an exempt organization. Okay? Now, if you look at D and E, those have to do with an organization that implements directly. Then F has again to do with indirect implementation. So that's something that we always going to correct. As we move along, we are going to correct those. So that D and E, so an organization that is engaged in active involvement in the planning, managing, and delivery of activities and programs. That is an international organization. Again, if you're using your staff, officers, and other staff and infrastructure belonging to the implementing organization, the delivery of activities and programs, again, that is direct implementation. However, if you're doing just collaborating with local partners and stakeholders to achieve the objectives in Kenya, that is not direct implementation. B as well, C as well. So once that is clarified, I believe then that would make things a bit more simpler. But so there's a mix up there which I believe is
So that is, as is mentioned, that is regulation number 13. So let's have a look at 13.2. And under 13.2, there's been trying to define what indirect implementation is, but we'll come to that. Let's take our comments first. Welcome. So Victor will take over from here.
Thank you.
What question was that? I think that is what we are referring to here, what indirect implementation is about the staff. The way I was saying, it depends with the nature of the activity rather than the staff, because your staff can be here for monitoring and evaluation, not directly implementing. That does not put you in the space of being an international NGO. But if you are seeking to have your staff who are seeking to implement the same activity, because what is of concern to the law is the activity, not even about the staff. Now, on the issue of the fees, I think we'll answer when we will take the other round of questions. Thank you.
Thank you. I think there's also a question that was asked about forums and whether the law should allow PBOs to freely come up with forums without the requirement for registration. So, like we said, there's a bit of a problem with now trying to come up with a different mechanism. We understand that is a critical element of the freedom of association. But there is a provision in the Act that says there will be a recognition agreement between the authority and the forum. So that is why we came up with a few requirements for that recognition. But it's not mandatory for you to be able to register with the authority. If you come up with a forum and you feel it's not necessary for you to be recognized by the authority, then you can come up with forums and focus between yourselves without necessarily having to register with the authority. But if you wish to be recognized as a forum, then it becomes necessary for the authority to come up with a criteria for recognition. I hope that answers that question. Okay. And then one other thing that I picked from the presentation before we go to the comments is about that there was an issue on agency. When we talk about you need a local agent for the international organizations, whether that agent should be a human being. By the phrasing of the Act itself, it seems to imply that the agent has to be a natural person. Let me use that term. But it's possible to, I think that's one of the areas that we may need to amend the Act so that we provide for what form this agent should take. Because like we said, for the sake of the regional hubs, if you have an agent, if you have an office in Kenya, and you need an agent there, it may not be one person. You may need a lot of staff to be able to run that office. So I think it would be, it's a good input, and we'll try to see how we can couch that in a way that is more inclusive.
Yeah, so from your explanations, it appears like the regional offices automatically fall under the exempt. Right?
Yes.
Yeah, so that now touches on a question that was asked by my behind there, where he was requesting if, say, an organization, so we have the Kenya country office and our regional offices still here in Kenya, where he was requesting if the returns could be made like joint, using the Kenyan registration instead of the regional office being the return, because it's one and the same organization. But now, following the explanation, it appears that since the Kenyan office falls under the NGO, the regional office falls under the exempt, then that would be possible.
Yes.
That's
yes,
correct,
that
right? Yes. Okay. Then kindly I need further clarification on the registration for suspension. And during the presentation that was projected, I was trying to trace the exact one, but there was something to do with suspension, something to do with 1 year.
Yes. There was a proposal. I remember my colleague even said we have had a lot of input on that proposal that failure to undertake
activity,
public benefit activity for
yes,
1 year.
within a period of 1 year.
Yes.
So the clarification I need is in several layers. So assuming we've been operation for whatever number of years, and due to funding issues, especially post-corona and what is happening now, post-January, USID draft and so on, for whatever reason, we are not able to do some activities because of lack of funds, no grants, right? So you are saying within 1 year we have not been able to undertake any PTO, whatever activities. Yes, so we will be suspended. Is that what you're saying? So that is for an organization that prior was operational. Now, second, so that's the first thing we need to address. So, and before I move on, okay, all right. So before I move from there, is first of all, my comment would be 1 year is too short a time. Even prior, pre-COVID-19, in our NGO sector, 1 year period is a very short time. Even in normal RFAs, request for application, from the time it is even put an advert, to apply, to getting feedback, to actually getting the grant in your account, it takes around that money. So 1 year is too short. Now, that is for the ones that were operational. Two, my second touch on that layer is for sort of new organizations, new NGOs, or whether local Kenyan or international or exempt, that have registered. So we've registered, we've gotten our certificate, everything we can operate. So if for whatever reason we are not able to land money and grant and operate within the 1 year, we will get suspended. Actually, from my memory, I think in the earlier regulations, it was 2 years. You can correct me, my memory is wrong. But even 2 years, we would request that you consider an extension for that period. Because the reality on the ground, if an organization was registered post-COVID-19, it might take quite some time before you start and actually become operational on the ground. So being suspended or deregistered due to non-activity, 1 year, 2 years, can be considered extending that period because of the reality on the ground.
What would be your reason for doing?
Actually, my thoughts would be, why are you even bringing this whole idea of the registration? Where did that come from? We are here for public good, and I actually love your new terminology, public benefit organization. Why are you in a hurry to register me? I'm not causing any harm. If anything, I'm here to support the government in improving the quality of its people. So what are you now to tell me you've not managed to land a grant? After 2 years, you are off. Why? So our and I believe my colleagues are with me on this. Kindly, personally, I've been trying to do resource mobilization for some NGO post-COVID. Believe me, I have traversed by all the key donors, and it's been very, very challenging. So I request on behalf of my colleagues here, kindly remove that clause. That registration. After 2 years, 1 year, non-active, it does not apply in our industry. It is not doing you, the government, any good, neither is it doing us any good. And the whole idea of any regulation is for the overall general good of all the stakeholders. Probably what could come in lieu of that clause is a report, probably, sort of narrating, articulating some of the challenges that we have encountered, why we have not been able to carry out activities in the period of 1 year, 2 years. And probably, if you must have a cap in terms of time, 5 years.
Okay, so now she's been radicalized. She moved from extending the period to saying that we delete the clause and entirety. So anyway, you're in good company, because in many places that you've gone, the proposal was that we extend that period to 3 years. But like you said, okay, you said 5. She says we delete it entirely.
Then you require a periodic report.
Yes. Yeah. So that's very good. What I'm getting from this sitting, that it was really very important for us to have this forum, because some of these things may have gone unnoticed, and that's a very good contribution. Like you say, we understand that there will be challenges in, we call it getting up in law, just setting up and creating offices and stuff like that. Maybe a year, that was a proposal. And as you all understand, the whole of this document is actually a proposal. Nothing is already cast in stone. So that's a good proposal. We'll, I think our team has taken note of that. We'll continue engaging, and then finally we say whether we go with that 5-year proposal or delete it entirely. So they're saying you say your name because they want to record your contribution, please.
My name is Susan Kihara. I'm speaking on behalf of my organization, it's SIAD. I know it may sound new because we are new. We are French, registered in Quebec, Canada, have been operating mostly in the Francophone Africa. And that is why the name, the abbreviation is SIAD, C-I-A-U-D. I've been championing the extension of our footprint in the Anglophone, that is English-speaking Africa, and starting with Kenya, because Kenya is very strategic in especially East, Southern, and Central Africa. So it is SIAD, so you can go to our website, www.siad.ca. In English, as you can hear, I'm championing our work for English. So it is just like Action Against Hunger, French, Action contre la faim. So it is a Comité International de l'Urgence et le Développement. So it is, but translation in English is International Committee for Relief and Development.
So now, just before we proceed, because we've been sitting for almost 4 hours now, let me know please if we want us to take a health check at campus. Yes. And then we can pick it up. I was given an express directive to begin from the back there, but they have overtaken if I will begin from there when we come back. So, should we take the break now? We get the answers and then we come back. Okay.
My name is Job Ojuok. I represent Relief International. My question was with regards to international PBOs and exempts. Your colleague did a good job explaining the difference between the two based on whether one is directly implementing or not. The other part that I felt was not clearly clarified was on fundraising, okay? Because if I'm registered as an exempt, I don't do any activities in Kenya, but I have country offices across the region who fundraise, including from donors in Kenya. They're not Kenyan donors, but they are donors placed by here by the organization structure. Can I still be registered or considered as an exempt organization? My other point was not a question but a suggestion on the registration of an organization who has not been able to implement activities for an entire year, okay? For an already existing organization, maybe as a feedback, you can consider hibernation. There are a lot of country offices which allow that. If I'm unable to get funds for a period of 1 to 3 years, I'm allowed to hibernate, but my registration standing stands until I resume operations. Thank you.
Thank you very much for those questions. I think now we go back there. Is there another mic that we can? If we don't have another mic, we can use this.
The name of this organization can actually be is only reserved for 30 days. Then after that, it's available for to be used by any other organization. Given that the Act envisages an appeal process, a review process, I think this would cause a lot of confusion in the sector where an already established PBO is suspended, but before they even appeal, before they implement whatever recommendations they're given, then their name is already out there to be used by any other, say, a new organization that is registered in the frame. So I think that would bring a lot of confusion, also saying that then they would have to rebrand and all that. So maybe, in my opinion, that could be removed, given that the compliance process might take a while. Yeah,
okay, thank you. Let's have this question, and then we'll come for another round. I think we already have a couple of questions that were asked before the break. We need to have them addressed before we end.
Okay, good afternoon. My name is
of that same organization, but now registered to operate locally, then that one that operates locally and implements projects locally will be subjected to the registration requirements as any other national public benefit organizations. I hope that's clear. Then if you have two offices, the one that is exempt from registration, perhaps because it's coordinating the activities in the East African region, or perhaps because it's giving money to other agencies that are implementing projects locally, then those are two distinct, they will have to operate as two distinct offices. Even if there is a coordination between them, but they will be operating as different entities. I hope we are clear on that.
It's more than coordination, it's supervision.
Yes, yes.
Yes,
yes. Perhaps
I think as rightly pointed out, these are two different institutions. One is governed, the exempt organization is not governed locally. It is governed by the global organism. And you've not registered a board of directors locally because you've not been incorporated. But the other one is an organization that is governed locally. It's a separate organization with its own board of directors. So first of all, we are not going to talk about supervision, because you cannot supervise an organization that has its own board of directors. They are responsible for governing that organization. So the best you can do is to have an arrangement where you define the relationship between these two entities.
Okay? So that then you can solve out those issues which are administrative. But legally, you cannot talk about supervision. You can't supervise another entity that is its own regulators.
So, we're coming back. Yes. Do you have a mic? Okay.
A follow-up question on that issue. So when you are applying for the work permit of the staff who are joining the organization, now there is usually an issue where you have to have somebody who is understudy, yes, an understudy. So are you going to, who are you going to declare the understudy? Yet maybe in that scenario, those international staff maybe are not even Kenyans. So when you're getting the work permit for those who are working, how do you go about it?
All right. Is there the other one a follow-up question as well? There was a hand.
I'm still not clear on the exempt actually. So what is the relationship between an exempt organization and the government? Is it under the PPO or any other government body that isn't clear? And I don't know whether I can go on to the other questions.
Okay, please. Did you get that? Just kindly, if you can stand up so that they can also capture your name and the organization which you represent.
Stella from Filmmaking. So just to close on the exempt question. So I'm still not clear under what is the relationship between an exempt entity and the government? Will it be under the PPO or it's under a different entity? Because if you are present and have operations in Kenya of any kind, even if it's an office that is supervising, you still have to have some kind of recognition with government. What is that for an exempt organization? Then the other clarification that I wanted to seek, so on the economic activities, is this something that is limited for national organizations, or it's also open for international NGOs to engage in economic activities? And just also closely related to that is what would be the alignment between the authority and the Kenya Revenue Authority as well? For example, in terms of recoupment.
For national NGOs, even fields employment.
Please come on that again.
Yes,
Please from your name. What's okay.
It's a term, it's a national NGO dealing with youth empowerment. Youth name is Now my main concern is because what we normally do is what we call capacity building. That was given level with both volunteerism and financial disciplines. Now my concern here is in regard to limited, resourcing. Initially, on a goal of the annual budget to 1 million. You expected to submit annual report account of those subjects. Whether we feel this will not really capacitate the operations. Now, whereas majority of these NGOs was included, we normally hinge upon majority of these international NGOs as partners in operations, in our advocacy and all that. As I said, to a given level, it involves some capacity building and some form of volunteership. So sometimes the budget may not, may actually be very, very low. Also this time around when there's an issue to do with the COVID. Remember when coffers are actually becoming very scarce in regard to, this kind of, to sustain maybe these operations. So we feel maybe when, they must be aware on how maybe possibly we can start this so that we have what you call a tired for prayers framework. Rather than just the organization doing it independently, we do our, returns or audited accounts with the affiliated organizations, most of those international. Because I tend to feel that kind of crowds may not actually be
much room in getting audited accounts. So perhaps we take that question and then we'll have the questions that have been asked addressed, or there are still many questions. Okay. Give us the mic. Can you closer so that?
Okay. My name is Cynthia. She asked a question, and I think I've got a few questions of the exemption of the regional office. It is exempt in Kenya, and it cannot oversee activities in Ghana. Where does it? We need clarity on that, because if it is exempt in Kenya, you see it can also not oversee activities in other countries. What does that mean?
Okay, I think perhaps it was not addressed, but the element of exemption we say it's about first registration. When you exempt from the normal requirements for registration of other PPOs. So if you're in Kenya, but you're not implementing any programs or projects directly, then that is the qualification for exemption. But if you're operating from Kenya to the other regions, but like you're not implementing also projects there, you're not here to implement a project in the Somalia, or say you are South Sudan, in the neighboring countries, that exemption applies in the sense that you are here, but you're just a coordinator. That's what we are talking about regional offices. You are here, but you are overseeing projects or supervising projects. Let me use that because we are saying that supervising is the more correct term. You are supervising projects in the region, but your operations are based here. You're operating from Kenya. So your status as an exempt organization is also is valid in that sense, that you are not implementing any other project in the region from here. Are we together? Okay. So we have a couple of more questions. I hope you can take this. Let's take the 4 questions and then we have them addressed before we don't want to lump so many questions together also. We use the time to address them.
Hi, my name is Damaris Kahori. I am from the Standard. Maybe specific in relation to the question. So we do not operate as a regional office. We do not implement Kenya, but the restriction from oversighting other countries. Yet that is a function of the regional office to have oversight of the region and to be able to support and coordinate. So if you're restricting the oversighting of another country, but it is very possible, then that's an issue. Then the second question was in the certificate. We cannot hear. I was asking with regards to that question specifically. In the morning, someone specifically said that if a regional office domiciled in Kenya, and exempted in Kenya, you cannot be able to oversight, for example, regional countries in Somalia or Sudan. And that is the essence of why regional offices exist, to be able to support a regional based housed in one country but support kind of oversight. So that specific mention of that you cannot oversight another country, that's a mention. Then the second question was, in the previous, in the old NGO Act, our certificate did not indicate whether we are an international organization or a national organization, just that we are registered by the regulatory body in Kenya. Now, in the new, as going forward, we're going to have a certificate that says that whether you're either international or national. One of the questions that I know will affect a lot of us is when it comes to eligibility for funding. There is eligibility for funding that is specific to national organizations, and that means that any organization that is deemed international, whether registered or domiciled in Kenya, would be automatically declared eligible. This is going to affect quite a lot of organizations, especially since Kenya becoming a middle-income country. The restrictions on eligibility are quite more stringent. So how are we going to go about that? Because if, for example, we roll out the regulation this year, we are looking at quite a number of organizations using a lot of funding, especially in the EU space. So maybe something that you can tell us about that.
Okay, so the follow in that regard, would you say that you want that certificate not to show whether you're international or not?
Because if, for example, you at front face, when I look at a certificate and it says national, international, and my eligibility criteria says national, then that means that anyone who is, you see, it means that not be eligible. So we would prefer if the certificate is registered in Kenya, because also the PBO Act has components of governance in Kenya, so we're already fulfilling those conditions. So we would prefer if the certificate is not mentioned that, because that means that quite a lot of organizations will use funding based on that, just the change of the certificate from national, no mention to international.
All right, thank you. I mean, those are very rich contributions that not only come from day-to-day players in the industry, and if that's an overwhelming
about an exempt organization, and I think we have made headway in terms of agreeing on who qualifies to be an exempt organization. We've talked about direct implementation, and we've also spoken about raising of subscriptions or funding in Kenya. And if you do that, you do not qualify to be an exempt organization. And then at the same time, we have agreed that if you implement outside Kenya, you are registered in Kenya as an exempt and you implement outside Kenya, or you raise subscriptions in another country, then you are not an exempt organization. And let me now put a case in point. Let us look at what the Act says about an exempt organization, because we need to get the wording very correctly in terms of what exactly does the PBO Act say about an exempt organization. And then from that point, we will be able to break it down from a point of understanding, okay? Let's look at section 11. regulations. So, an organization which is registered outside Kenya and which intends to operate in Kenya shall apply to the authority for a certificate to operate in Kenya. That is an IPBO, that is international. The authority shall take any of the following actions on an application made under this section. Exempt the organization from registration and instead grant that organization a permit to operate in Kenya. If that organization does not intend to directly implement any activities or programs in Kenya or operate from Kenya to implement any activities or programs in another country. The authority shall not exempt an organization from registration under this section if that organization intends to engage in direct implementation of any activity or program in Kenya or operate from Kenya to implement any activity
office fundraises with, just say, a government that's based here, an embassy, right? And there's a call for Somalia and Kenya, and they fundraise that, and they come to my office and go, hey, we've got funding for you, and then they go to Somalia and say, hey, we've got funding for you too. They've done the fundraising, but I'm still the implementer, and I'm still registered as a bona fide PBO international with the new classification. So in theory, they're fundraising, but on my behalf as the implementing organization. That should be okay, eh? Because they're not receiving it directly.
The funding meant for Kenya. The issue is whether the funding is meant for Kenyan organizations. If the funding is meant for Kenyan organizations, you are not eligible.
But if you're doing on behalf of the other?
No. If you are an exempt organization, you cannot engage in that call. Because you're constricting the space for local organization. That was the intention, and I think that's a policy issue that the government of Kenya was addressed. So let's be very clear. If you want to engage in local resource mobilization, then there's the option there for you to incorporate as an international organization. So you can't have your cake and eat it.
Yeah. So just to clarify, just back to my example. So in this scenario, just say it's the French government, right? We would advocate, my regional office would advocate, I would advocate, we would jointly advocate for the French embassy to give us funding to operate in Kenya, okay? But the money and the relationship is between potentially our HQ and Paris, and not the entities on the ground here. So you have to understand there are various entities, and especially as organizations that have networks of over 60 countries and sometimes 10, 12 headquarters. The relationship between the donor and the organization is usually at the state capitals outside of Kenya, either between New York and Paris or wherever it may be, and then it trickles down. So in those scenarios, it's not local fundraising. We're actually sitting in a foreign embassy, on foreign soil technically, and advocating for funding.
Because, okay, I know of instances where, so that money can be made available for you directly, France, right?
But advocated here.
Yeah, no, but the minute
does not necessarily have to be local families.
Okay.
Or rather, explain to you,
Okay, okay.
what do you people mean by local families?
Okay.
I
So
think that's what we are
my understanding is this: that the Canadian embassy typically would have money that it has set out to support organizations operating in Kenya, isn't it? So when they make a call, they're asking organizations operating in Kenya to respond to that call. Are we together so far? So that is money that is in country, meant to support activities in. So if you respond to that call, you are raising money locally.
For activities that is Kenya, that is local part. That's local.
Yes, that is money that is made available locally for local organizations to compete.
I should not apply for that.
If you are an international organization, in terms that is registered in terms of section 11(2)(b), okay, meaning you have been incorporated, you have a local board of directors, you are free to apply for that call. If you are an exempt organization, you may not apply for that call. Yes, yes.
Any calls restricted to Kenya borders.
Yes.
What if the Canadian embassy, on behalf of Canada, makes calls for funds sent to Somalia or Sudan? Am I restricted?
No, obviously, that we have got nothing to do with that, as far as I know.
But it is only facilitated for one country that has a different. So we need to explain to them the clear distinction that funds reserved for Kenya.
Well, whatever the case, I believe they've heard whatever you said and they've been noted. So is it possible that we can move on from this?
Even if a call, even if it's a local call, the fact that the resources are not coming from the country complicates this conversation. Because if we continue with this proposal as we are, then we will definitely have an implication of how to look at resources in the country where the culture of local resources is taken away. Mine is what you said initially when you were the high court ruling, I want to tell us whether there has been an appeal or a stay, because there hasn't, then I want to imagine that what the high court ruled on is what I understand, because I think that as a petition for us to put situation next step. Guide us on that with your research. Thank you.
Just must before you, I'm told these proceedings are being live streamed on YouTube, and because of that, we do not have a good amplifier there. So when you're given a chance, please to contribute. We request you to put the mic as close as I have done, so that they can hear you, and the people that are following online can be able to hear what you say. Mercy, you want to proceed with the questions, or you want to take the last?
I think I can proceed and then we'll do the last round.
Okay.
So on the High Court ruling, when I spoke, I provided clarity on the fact that we have a stay order and we have an active case in the Court of Appeal. We have appealed the case. So I also indicated that it is the same court that had issued the judgment which actually set it aside and issued a stay order. So that is the position. Now, there were some questions that had also been asked, and whether economic activities and income generating activities are applicable to both the national and international NGOs. Yes, they are. They are applicable to all the entities that are registered under the PBO Act, so that is as clear as it gets. The timelines for registration, 60 days. We used to do 90 days, but since we automated the services, we now do within 60 days, and this is in line with the PBO Act. And then we've also taken positively the comments on having the organizations that are, let me use the ones that are unable to file their audited accounts, having them to actually not file audited accounts, so that they also are clustered in a different segment or in a different tier. So we've taken that comment very positively. We've taken note of that for consideration. And then also on the role of the regulator in tax exemption, we also took note of that particular question to say that we will actively be engaging the KRA. We have already started doing that, and we have had various sessions with them so that we can be able to streamline their rules in terms of exemption for charitable entities, alongside that which the PBO Act also does provide. There was the question on the regulations being silent on government to government engagements and the matters to do with entities such as the UN. And the regulations could not provide for that because this is not a provision in the Act. In fact, when you look previously, the NGO Act, we were not mandated to regulate such agreements and such entities. So that spirit has been carried forward, had it changed.
And there is a certain limit, I think it's 150,000 that are supposed to be, maybe they are not supposed to pay tax. But when it comes to the board allowance, is there a specific amount that we are supposed to pay that is a limit maybe so that we can start paying tax per individual, especially those who are tax exempt? Because in a month, maybe if they have a salary somewhere else that is below 150, inclusive of, when you include this board allowance, it's still below 150, it would not be okay for you to file their tax for that amount. So that was my question. The other question was on the issue of the understanding for the exempt. So if these people are not registered, maybe the organization does not have activities in Kenya. So if these guys, the international staff, are maybe going to work in Kenya for whatever reason they are going to do, how do you apply for the work permit and special passes, assuming that these people, there is no registration, there is no workplace registration, there is no understudy because there are no operations in Kenya. So how do you apply for that? Thank you.
Yes, my name is Nelly from Mennonite Central Committee. I have a question which is a follow-up on the work permit recommendation of the special pass. On the requirement number 9, you require a copy of the advertisement done in at least one national circulation daily newspaper in Kenya of the required position. In this present age and era, is it possible to also include maybe a locally accessible website or something like that? Because I think that is, yeah.
Thank you.
And then the other one is number 10. It says interview questions, long and short list of applicants entailing name, age,
nationality, sex, contacts, and qualifications. While we appreciate that that is a good requirement, but also the data protection for us, for instance, when people make applications, similar to what you guys have here as data protection statement, we have that. So we are going against our applicants, like the obligation that we make on our end. So I don't know how, maybe you can remove some of the things, and we don't have an issue giving you interview questions, the long list, ensure of applicants, but then it's a bit too intruding to give some of those personal information. Thank you.
Thank you. Is there was another question here? Okay.
Thank you. My name is Sifa from World Review. I think for me, I just wanted to ask for clarity about this forum thing and the recognition that you encourage forums to form. I think in the past you've had these forums evolving either in working sectors or in collaboration with the county governments, and they've worked seamlessly pretty well. We've had forums where sector areas just come together to respond to a call or build capacities. Now, in earlier statements, someone said from your team that it's not a requirement that NGOs be part of forums. So my question is, if there's a fee for recognition, what value does the authority bring to the forums? Because otherwise then you just have them as they've always been, and just inform you for a formality.
Yeah. All right. He also belongs to that school of thought that the authority should not have a role in terms of regulating forums.
Not necessarily, but is it defined? Because I think all I read from the document is a fee for recognition, but we know how our forums have always been operating. If I come into, let's say, the Act Alliance or the Conservation Agriculture Hub, there is something that defines our interest in that forum. And so members who come there, even if there is contribution in terms of subscription, we know clearly why that subscription is there. And it's agreed on the members. But when you come and you say there is a fee for recognition, the question is, what value do you bring on the table? There's this thing that was mentioned over the document called self-regulation. What does it really entail? Like, what freedom in terms of regulation do we get for getting the recognition? I think that will come in very clear.
All right.
Yeah,
that's clear. Okay, the fees is always high. People always say the fees is high, but I mean, you also have an opportunity to contribute on those specific fees proposals. Like if you feel the fees is too high, just don't say it's high. Say to you what is reasonable for that particular service. So that provision, I know it's overwhelmingly, everybody will see the fees is high, but we want to hear specific provisions on what do you think to you is a reasonable fees for different services.
So since I still have the microphone, maybe just to make a comment on that as well. Maybe some of the things to avoid this back and forth would be the document to be as explicit as possible. What informs you to say 70,000? Because then if there's a justification for that, it makes sense that, yes, this makes sense, you have to agree to. So I think maybe the clarity of the document. There's another thing I wanted to follow up on about the international exempted agencies and the international registered locally. When you talk about monitoring, there's the aspect of accountability and institutional strengthening. There are organizations that are keen on building the capacity of their partners, local partners, so that they are able to execute and implement programming better. Do you qualify such institutions as institutions that must have the local registration, or they can be referred as exemption? They are not doing necessarily implementation, but their level of engagement is beyond, with the partners, the local partners, is beyond the monitoring. They are looking into things to do with system improvement and such.
Capacity building and that kind of thing.
Yes.
So, understood.
So I think we have one question here or contribution, and then we can address those ones so far, and then we can proceed. Please give the other mic.
Thank you. Once again, my name is Janet Ngombalo from Christian Aid. And I think
you said
Christian Aid.
Christian Aid.
Yeah.
Okay. You can kindly start up if you can.
Okay, thank you. My name is Janet Ngombalo. I'm the country director for Christian Aid. I just wanted to allude to the reason why we are here. We are here for public participation of regulations that were supposed to regulate, not to regulate, to support the sector. I think they were not meant to be punitive, or in fact, because our consultant kept talking about the history, it was supposed to help the sector self-regulate. It was not supposed to bring an authority or something to come and police the sector. And what we wanted to hear in this meeting and what from the consultant is the spirit of hearing what the sector is saying and providing clarity where there is none. So I just wanted to allow the consultant to allow for that public participation by the people in this room, hear what is not clear, because it means when we are asking, it's because there is lack of clarity, and we have agreed after this session we will go and make sure the document has clarity so that we are not keeping on asking. So what we are saying is allow for that spirit of engagement of the people in the sector. What they are saying is not there is not there. Let us have it there so that tomorrow when we come to validate the document, we do not end up in the same process. So it was that spirit of engagement and that spirit of the law, because we were very clear it was supposed to come and self-regulate. In fact, when it started, it was not even going to be compulsory for you to move. But we are not even disputing that, because we will agree to move. But allow the process to also be as open and as supportive to the sector. Otherwise, it just came for that purpose, to help the sector self-regulate, work together, feel supported, expand it, and where there's no clarity, just allow for that purpose. Thank you.
Thank you. Thank you very much. Following up from
Janet.
Said, the provisions that we have in the regulations, like we explained earlier, most of them were trying to implement the provisions of the Act. For some of those provisions of the Act, immediately, the Act was passed, there were provisions, even to the authority itself, they considered to be a bit problematic. So these regulations, as Mercy explained earlier, are a product of a court decision that said, because when the authority wanted to refine some of those provisions of the Act through an amendment, the court said you cannot go to amend the Act before you make an attempt to implement the same. So like you say, there are provisions there, like what you talked about, like some of the examples that you've given up that are practical to the sector in terms of, for example, the limitation of exempt international from doing local fundraising. Those kind of things that come up from an attempt to implement those provisions of the Act as they are. So if we identify some of those areas, there are many other areas we acknowledge that would have been better clarity in the Act before it was passed. But all of you that have been in the sector know the process that it went through, and it was passed as it was. There are sections that talk about the registration, that are a bit confusing. So all those problematic areas, we try to make regulations that to the greatest extent possible would address those issues. But that's where we are here also. Some of the proposals that you give, in future, if the act is due for amendment, then they may also be used in that process. So this process, there is no gagging of anybody. Everybody should be able to give out their exact sentiments on how they feel, and how they feel, most importantly, we can come up with a draft that speaks to that spirit you're talking about, of giving effect to self-regulation. That's when the proposals that were being given about allowing forums, to freely engage without necessarily even having to report or to register with the authority, then that provision is there. Like you can form forums. If you don't feel it's necessary for you to be recognized as a forum by the authority, you can operate without it. But if you also say it's important to be recognized, but the impediment is the fees, then that's a very useful feedback. Then you can say, let's freely form the forums. The authority has no role in how we conduct our business as a forum. So they have no business charging us fees. Then you give that contribution like that for consideration, because it's a reasoned contribution, isn't it? So every opinion is valid, and I mean, with that kind of justification, like you speak, like what you've spoken about forums, the authority can also say we incur some little administrative costs in terms of registration, keeping a register, and then you say, okay, then what's a reasonable, is what the fees that you proposed for registration of forums reasonable? Does it reflect the kind of service that we are getting from the authority? That way, then you get a good balance. Instead of saying this is a bad idea altogether, or the authority is charging too much fees, then that engagement, when it's reasoned like what you've spoken about, I think it gives everybody a feeling that their views are being considered, and most importantly, that you pay for the kind of service that you get from the authority. In that spirit, in this forum, every opinion is valid. Some of them, like I've said, may be difficult to implement immediately because of the limitations of what already the Act provides. Like now, if the Act has provided that you can register 4 types of PBOs, the regulations cannot do anything about that state. Maybe in future, as we consider amendments, then you can say, maybe these 4 provisions do not make sense, we want 3. But for now, the regulations can only implement what is already provided in the Act. And for the contributions that try to bring more clarity, every submission on that line is very valid. There are a number of questions that are already raised. I don't know if there is one last question before I can give my colleague a chance to address, or let's give the mic to... please proceed.
All right, hello everyone. Mine is not a question. My name is Rachel Wahome. I work with Refugee. I will make reference to part 5 of the Act, that is on the establishment of the dispute tribunal. The regulations have not established or have not provided procedural requirements when approaching the tribunal. That is in terms of timelines, the forms that you're supposed to fill, are you going to be represented by an advocate or not? So which leaves rooms for unconstitutional practices in the future. So it's good that the regulations do reflect that.
All right, thank you. Any other questions? So I think we can have the questions asked so far addressed, and then we can come, I mean, if there are more questions that come up as a result of the answers, then we can do another round of questions. So don't want we are as soon as there are concerns, we will be happy to address them before. And like you say, this process continues even after this exercise. If you feel there are specific contributions that you want to make or engagements that you want to have with us through writing or like we said, the objective here is to come up with a clear a set of regulations as we can under. So, Mercy, please, you can address some of the questions. Okay.
Thank you. I think
Thank you. I would like to address one question so that we also move towards the conclusion of the process, and so that we also allow more feedback from the team. We have our rapporteurs who are recording the feedback, the comments that you are raising and the questions that you are raising. So the issue of the tribunal, what is basically happening is the establishment of the tribunal is a role that is mandated on the judiciary. It is not the mandate of the authority to establish the tribunal. Because then if we were to do that, it would mean that we are cross-cutting between like being a regulator, decision maker, and then again being the same people who are handling the disputes. So that is why intentionally it is not in the regulations. When you look at the Act, it indicates that the judiciary, the tribunal shall be established by the judiciary, and that has already been done. There is a register of tribunals, and it is up to the judiciary and the register of tribunals to now issue the appropriate timelines on how they will receive disputes. If it is forms that they will need, it is for them to develop these forms, so that as the regulator we remain within our confines and the tribunal remains within its confines. Of course, then what we expect is once they have actualized this documentation and the processes, what we expect is now for stakeholder engagement, so that we are enlightened on what exactly is happening with the tribunal and what next. Thank you for your comments and feedback. I think I'll give it back to Vic if.
A question on employees and what happens with the understanding that are working
with just came from the how exempt entities. Once they apply, the result is given up. So immediately in this case, as they seek to employ both Kenyan and non-Kenyan employees, they can now go ahead, advertise, and employ. And when they're seeking employment for the expatriates, they'll get the Kenyan understudy, who is supposed to learn from the expatriate and within time be able to take over from the expatriate as they return back to their country. And we remain with the skills that have been imparted to the Kenyan who is able to take over that particular role. There's also another question on the issue of allowances. I'm not sure. Do you pay board members your allowances? Yeah? Some pay. Some of you pay. Okay? Yeah. I wish not to go into that because it's a very controversial space. Should they be paid? Should they not be paid? But the Act is very clear that it's supposed to be a voluntary sector, where they should not be paid allowances. But they can be reimbursed for their costs that they've incurred for them traveling and executing their role as board members. So when it comes to now to declaration of their reimbursements in terms of their, for purposes of the taxation, I feel most of the reimbursements are usually tax exempt, because they are part of the cost that they have incurred as part of their movement. There's another question on the issue of the issue of work permits in terms of employees, the expatriates seeking to work in Kenya. Well, we have taken note of the issue of the long list, short list in terms of data privacy. We will come up with a way of trying to go around it, but we don't breach the applicant's details. But we may get information in terms of the numbers and the responses and all that. And then the issue of the advert, newspaper, the website. We are looking at how are Kenyans, look at Kenyans, like how are Kenyans able to access this information that there's a vacancy here and they're given equal opportunity to apply for it. So in the previous experience, people who advertise for positions would always place them on the newspapers. With the advent of the technology and all that, people are now placing them on websites and all that. So, okay, we'll look at it again and see if it's possible to have a balance. But usually, for purposes of fairness, that if someone has no access to internet, how can they be able to see that there's a vacancy here? So we'll look at it and see how to go about it. We have taken the note on the issue of the fees. The fees that you are currently applying under the NGO's regulations were made and amended in 2012. 2012, yes. So you see, it has taken all that time. And you're always saying the economy is bad, things are becoming costly. Even the regulator side, things are becoming costly. And that's why the fees have been increased in a way. But you've taken note, in fact, from all the meetings that we have gone around, the concern has been that the fees have been highly increased. So we'll look at it again and see where can we have a balance. But we don't have the regulator also struggling on the other side. We try and see where we have the balance. Okay. Yeah. There's that issue of the material changes in terms of the fees. It's not clear how much you will wish to be in terms of what you are able to pay. Although for the other regions they have been telling us it should remain at still the same figure, 4,000. We'll see what to do in terms of the fees and also even the kind of service that you're requiring. So we will also look at that. There's the issue of the audit reports for all PBOs. See, now this is now one of the things that you're talking about. If the Act provides that all PBOs must provide their annual returns together with their audited reports, there's nothing much you can do in terms of the regulations. Okay? The concern has been raised all over the country that it's very costly to conduct audits for even small organizations that receive less than 100,000, less than $1 million. So if that is the case, then what happens? So given that the Act provides that they must file them in the audit reports, then we need to see how do we have the market or the fees standardized for those who are going to conduct those services, so that it's not too costly to the smaller organizations. That we already discussed with ISPAC, and they're talking about it's a free space, a free market, but then we need to still negotiate with them and see, is it possible to have a standard fee for the PBO sector? I think that's it. Okay, yes, there's the name of the NGO, or the PBO. At the point of application for a name reservation, you will see it under Regulation 4. Once the applicant applies for a name reservation, the name is reserved for 60 days. If the applicant is not ready to apply, they can apply for an extension for another 60 days. The question that was raised earlier on the availability of the name once an NGO has been cancelled. And the Act talks about 30 days after cancellation. So maybe I had misinterpreted what you're asking. Yeah? So if that is the case, if the entity has been cancelled and now the name is available for use, initially the Act talks about an appeal process. So you also require to appeal within that time frame. If you appeal within that time frame, the name is not released for other users. If you don't appeal, then maybe you have agreed to the cancellation. The name now becomes available for others. Okay? So I think we'll end there. Yeah.
Thank you, Sam, for addressing that last round of questions. I've not called it a last round of questions, but I said if we have issues arising from the answers that have been given, while my colleagues were addressing the questions and the concerns, we can take one more round so that we go close for some important contributions. Any more contributions, questions? All right. So 1, 2, 3.
Thank you.
If you can kindly stand so that they're able to.
So no, my question is about the transition. You know, we need to re-register the ones that have been registered in a different other category and now to move to, for example, the exempt category. What is going to be that process look like, and what do that mean? Because you mentioned there's no provision for a merge, you know, so I'm thinking like, do we need to close completely that entity and create a new one and then move our staff and our assets? So I'm starting to think operationally what that would look like, because we are not a small quantity of NGOs in the same situation. So if you can explain that a little bit more.
Thank you. I mean, that's an important provision. I think it was partly addressed in the morning when my colleague said, by virtue, those who are operating under the NGOs Act, by virtue of the enactment of the PBO Act, there's an automatic transition. Because now there's no framework for NGOs. And they say the law abhors a vacuum. So there couldn't be a vacuum there. So by virtue of law, all NGOs are now considered to be PBOs by virtue of the enactment of the PBO Act. In terms of the mechanics, the detailed mechanics, because now you have a registration certificate that is reading NGO, you have bank accounts that are already opened in the name of that certificate, and those kind of details, those will be addressed by our operations team. But by virtue of the law, all organizations that were operating under the NGOs Act of 1990 are automatically transitioned to the PBO Act. What I can note from a legal perspective is that there are certain new requirements that are provided under the PBO Act in terms of compliance. Let's say a good example is on the board members. You are required now to have at least a minimum of 5. So you may have not had those that kind of minimum number of directors in your previous organization. So there's a period that was given for transition which has been extended for compliance. So what is supposed to happen is to demonstrate that in terms of this transition, that in terms of the legal requirements for PBOs, that you've complied. And that's why there's that bit of a window to look at those requirements, try to comply with them. So the issue that comes out is to show that you are compliant, and the authority should be able to give you a compliance certificate, or to show that now you are a recognized entity, a compliant entity, not recognized, because you're already recognized by virtue of the law, but that you are now a compliant entity under the the new act.
From the NGO to the international PBO, but what happened to the regional offices, like some of us that are going to move to the exempt international? That's a very different regulation, and also look like we don't need to be incorporated, but receive a license. So I think that's my concern, because at the moment we are registered like an NGO.
So you're saying for that new category of exempt, how to transition and the mechanics of it? For the exempt organization, it's a new provision. Like it's supposed to, under the act, it's a new provision that has certain requirements to it, which you are supposed to demonstrate. So this transitional period is also supposed to allow you to be able to comply with those provisions. But in terms of the actual mechanics of how much maybe that will cost, what role the authority can play, I'll give it to my colleague to answer that from the operations perspective. But the whole idea is that there are certain new requirements that you have to meet if you choose to go that route. There was a question that I think my friend said, there's this category of international PBOs. So I heard him ask whether it's an oxymoron that we are calling them international, but we are limiting them from doing everything that should otherwise qualify them to be international.
Yeah, international, locally incorporated is the oxymoron.
True. I mean, that's a good input, whether we should actually have that classification altogether. Yeah. But one of the most important things that you made from the provisions of the Act, that those international organizations, there are certain requirements that are not similar to national PBOs. For instance, you can have directorship that is international, like it's not Kenyan, but you're required by law to have a minimum of 1/3 to be local directorship. So that's different. And because of that, there's an international character to it. But if you don't think that international character is sufficient, we'll consider whether that classification, how we so that it speaks to the function and requirements that are provided by law. You want to actually give him the mic. Give her the mic.
Just as an addition, what she's saying, let's not complicate, let's not add new layers, like now compliance certificate won't be a new process altogether. So what we are saying is still simplify what needs to be done. Maybe just a checklist is on what you be required. Then through your supervisions, you will support organizations to get there. But if you start now saying a compliance certificate, now that's another whole process. You have a registration, you now want a compliance certificate, you want a license to operate, you're adding another layer of engagement which then beats the purpose of the act.
I hear you. Perhaps the point there to take is that you are just required to comply. And the authority will have a way of checking that compliance. And once you have complied, then you are duly, operating under the new legal framework. There's a
I just want to add to the question she's asking, but from a slightly different perspective. So let's say we have an office which is considered regional. Sorry. So let's say we have an office which is considered regional.
Okay.
But my name is Nelly Shongo from Kodate. So we have an office which is considered regional, but it is also managing the Kenya operations. How do you categorize it? Is it international? So I would be responsible for managing operations in Kenya or implementation in Kenya, as well as overseeing activities in the other countries, for example. Yeah.
So that clarity thing, maybe you can explain to us.
So you're saying you have a locally registered?
Let's take an example. Let's say for data.
Yes.
So we have, for example, a regional office, and we have the director of the regional office being.
Thank you. Any other questions? Okay. Mercy. So we documentation. Okay, so now.
Yeah, so the action points, what you require from us so that we are compliant.
All right. So that we do not overlook the concerns of key stakeholders in terms of coming with up with the final draft. So this input today, from my view, has been the most useful in terms of scrutinizing what it actually means to have these regulations for the players that have been involved in the sector for a long time. So these are draft regulations. Your concerns, questions, and input today are supposed to refine them so that now, when they go after these exercises, this is like almost like the last round of the public participation exercise. We've gone to more than 12 forums trying to get this feedback. That feedback will be incorporated, this feedback from today will be collated and analyzed with the feedback from all the other regions so that we say what is the majority feeling about civic provisions, like what we've been speaking about, exempt, international, bestowed. What does it mean? All those views will be digested. We refine these draft regulations, and then when we feel that we have incorporated the stakeholder input and public views, then this draft will be taken to Parliament. From there, once it's ratified by Parliament, then it becomes regulations. So from today, I may not be able to give you exactly what you want in terms of point to point of what to do, but I'm hoping that from the input that you've given us from today, we'll be able to come up with more responsive, more clear, and more friendly regulations that facilitate the sector as opposed to curtailing or impeding the operations of the sector. So that will be my response to that concern. I think from that, I can give my colleague to address one or two questions that you asked, and then we can wind it up. I hope I've addressed your concern. Yes, yes, because this is work in progress. We have not come here to say what we presented here is final. We are saying these are proposals. We are subjecting them to stakeholder and public views. Once we refine the regulations, these are draft. This feedback will go into refining every aspect of the regulations that we've spoken about. For the aspects that we've seen are problematic, even to us in terms of we could see there's difficulty in understanding certain aspects. When it is exempt, are they allowed to raise money locally and that kind of, where we've seen that there's difficulty in the consumers of this regulation understanding what is they actually mean, then we'll go and try to fine tune those ones. There's never 100%, but I can assure you that from this exercise, very meaningful proposals have come out of it, and the next draft will be definitely better than we have here. And once that process is complete, then we'll have a validation conference where the people that were involved in these public participation forums will be called upon to look at the refined product and say to what extent their views or their input was considered in the final draft. So there's still a bit of room. Those who still, for those, the issues that you feel strongly about, like that issue of funding, like the issue of, we've discussed about regional officers, the exempt NGOs, what can they and can they not do once registered? So those issues, for those of you that have already made contributions to it, we've taken note. But if you still feel you strongly need to submit views on that, we still encourage you to do a memorandum, send it to the email so that it forms part of the material that will be analyzed when refining the draft.
Thank you, Victor. And you seem to have actually wrapped it up correctly. As you have said, with this process, we are here to collect the views on the regulations. But as we do this, we are also learning from ourselves and what actually it means and how it's going to impact the people that are supposed to be regulated by these regulations. Because at some point we may have been biased in terms of what we are only seeing as a regulator, but the feedback is really important for us. We had mentioned this earlier, that as we wait for the regulations to come in, we know of the things that definitely must be amended because of compliance with the new regulations as they come. So Marcy had mentioned the issue of the constitution, the issue of the structure of the board, the issue of the certificate itself, based on which category you're going to take. Those are things that very clearly must be addressed. But how then that comes after the regulations have come out? Again, there is the other aspect of provision now to the regulatees on the sample document that they're going to use for this process. So you're already drafting them now. Draft constitution for this particular category, draft constitution for this particular category of the PBOs, even providing draft minutes for you, but it enables you to be able to easily adjust and just put the details and apply for purposes of updating of the records. Again, we have been having issues with the records of our regulators, the PBOs. So this is also an opportunity that we are going to take for you to update your contact details with us. So we are also doing that on the site, part of this process. What is your new contact details, your new address for your offices, the email address? But as we move forward to the next phase of now regulations, we have clear details about you and who you are and where you actually operate. Because we now have around 14,900 there NGOs registered. And out of this, we have a compliance rate of around now 47%. So we are still struggling getting those other ones. And they're going to use this process now to clear this space. Then now transition the PBOs as compliant as they are, then you move forward from there. So we are still looking forward to hearing from you, especially what Peter said. Specific areas that you feel we may not have gotten it clearly here, you can say put it in writing. JB, we can have the email address for the memorandums to be sent on email, but as we receive them, we also put them into those documents. Again, our office is still open. because people have been coming in to submit physical memoranda to offices. So if you have any, you can submit that one to enable us now put that into consideration in the drafting of the regulations. So thank you very much.
I just want to ask a question for today. Is there anybody who came up with a memorandum and we have not received it? Is there? Okay. So it looks like, oh, you have one. Okay. So there's a memorandum and then there's the questionnaire and the forms that we gave for those who would have wished to present their views in writing. So as you leave, you can leave them at our registration desk. There's something you wanted to address. Is it addressed or you want?
No. I think the question Stella asked. I don't know whether Stella is in here. It has to do with tax. And issue what is allowed in terms of tax exemption.
If you're engaging in business as a public benefit organization, there are two issues you need to consider. One, is the business a primary purpose activity, meaning it is directly related to what you are doing. So, for instance, you are engaged in the education sector and you are running a school. Okay? That's a primary business activity, assuming that you are charging school fees for the school. So, since it's directly related to your charitable purpose, it is considered as a primary activity. And that one, first you can carry it, you can conduct that business under the name of the organization. Two, the income that you generate from that business is tax exempt to the extent that all that income is applied towards your charitable purposes. Now, on the other hand, if your primary purpose is to advance education, but the business you're running is perhaps is a hotel, right? That one is not directly related to your primary purpose. So for that kind of business, first you are advised to set up a subsidiary, run the business. Then two, that subsidiary, once it raises, if the profit generated from that subsidiary, then the subsidiary will donate that money to the NGO. In terms of the income tax, if you look at the income tax charitable exemption and donation rules, there are very specific requirements on what you're going to do. So you donate that money to the NGO or the PBO. The PBO will confirm that it has received the money. So that is the process. So it's very clear. It needs to be clear whether it's a primary purpose or it's a secondary trading activity. That's all.
All right. I think unless there's any more concerns, I think we want to wrap up this session here. But if there's a concern, I'll be happy to address it. But on behalf of the CNK advocates and the authority in general, I want to thank you for being very engaging today and for the contributions that you've given us. In my view, this has been a very robust and thought-provoking session, which I hope will translate to a more refined draft that will serve this sector for a long time, for posterity, even when some of us will not be here. What you've done today, the contribution that you've given today, hopefully is for the betterment of the sector in general. Like you said, this is an ongoing process. Have a prayer to close up the session. So, welcome, Mercy. Oh, there are two. I meant you.
Okay, thank you, Victor, for taking us through the day, and also for Joshua. Mine is really, really very simple. It's to say a word of thank you. And I would want to first really say thank you very much to ACTED on behalf of the INGO Forum for actually hosting this forum today. We are very, very grateful to ACTED and the INGO Forum. We've also had Inform Action, which has actually been providing live streaming, and we've actually done live streaming for all the forums that we've done around the country. So we are very, very grateful to Inform Action. Again, CNK advocates on behalf of PBRA, we are very, very grateful. Today being the last official public participation forum that we are holding, even as we are saying that the space is still open until the 25th, we really, really appreciate CNK advocates for taking us through this process and supporting us, the authority, in terms of the public participation, putting together the draft regulations, and of course they are with us all the way until we submit the final draft regulations for the next approval process. Again, all PBOs, including the members of the NGO Forum, you have really, really been supportive. We've had a lot of your members supporting us with our public participation forums in the regions, in the counties. We really, really appreciate that partnership and the support you have given us all through since we started this process, since we launched the draft regulations and up to this point. And we are still looking forward to work with you the rest of the journey and to continue partnering with you to actually ensure that the letter and the spirit of the PBO Act is realized. Last but not least, I would also want to take this opportunity to really, really appreciate our DG. He would have really loved to be with us here today, but due to other commitments that come with his office, he was not able to be with us here today. But he had given us all the blessings for this forum. And he also really told us to really pass our appreciation, particularly to the INGO Forum, for facilitating this forum today. All the other PBOs that have also been supporting us and that continue to partner with us, we also really, really appreciate. Lastly, our board of directors at the authority, we would not have been able to actually go through the entire 1 month process without the goodwill of the board. So I would also want to take this opportunity to also appreciate the board. And to all of us here present today, I think we should not take it for granted that we've been sitting here since 9 o'clock. And as Victor has mentioned, the engagements have been very illuminating. We've picked quite a lot. And I think this forum has achieved its objective. We thought that it was very critical to have a separate forum for INGOs because then there are some unique issues that we might not have been able to canvass through the regional and the county forums. So we really, really don't take it for granted, the feedback that we have received here today, the input, and we do feel that that input will go a very long way in terms of ensuring that the end product, in terms of the final regulations, actually seek to also facilitate INGOs that are operating from Kenya. Kwa hayo machache, asanteni sana, and God bless you.
Pigie makofi. So I think that officially marks the end of our engagement here today. So just to wind it up, I believe that it's a Kenyan tradition to wind things up with a word of prayer. So I was wanting a volunteer to pray for us.
Good evening, good afternoon. Okay, my name is Wesley B. I'm from Crandall Africa International. Let's pray. Dear loving Father, in the name of our Lord Jesus, thank you for this opportunity to meet as INGO and deliberate about PPO public participation. We have seen your hand from the beginning, from 9 up to now. Thank you for the ideas. Thank you for points we have discussed. We pray that this sector will bring transformation to this country and to your people. We use this sector to promote your will, and we pray that everything we have discussed will be beneficial to all of us. We also thank you for the participants, and we pray for PPO authority. We also thank you for this facility which we have used here. We have had good opportunity to discuss, and we thank you for this. As we leave now, we pray for journey mercies, and that when we arrive in our destinations, we remember to thank you and to glorify your name. Thank you for everything, even the resources which we would like to use. We pray that you are going to provide for us. We thank you and worship you. In Jesus' name, amen.
Thank you very much. We wish you a lovely afternoon.